Item number 40.
46.
Three.
What is it?
This is suffering from higher fever. So,
There's an office note. What is the office note for?
actually, I'm not.
We'll see when the matter reaches. I don't give this type of adjournments at this hour. Seven.
Paragraphs acts and basically institution lordship, the question is also not specific question. So lordship may amount to the question to find the session.
Miss Jivara, appearing on behalf of the petitioner, submits that the petitioner would like to withdraw the instant petition with a liberty to refile, taking into account that certain factual aspects needs to be inserted. So taking into account the above, the instant petition therefore stands closed on withdrawal. Liberty, however, is given to refile. Withdraw. AI Ali appears for the ECA. Why?
On the last question on what suppose reference find now I been for a comment on 5 and what we need some more time because the memory is so old that the files have not been found. So,
We'll see when the matter is taken up.
Oh, Mr. Item
Yes, what is your case?
Right. So compliance of the order number is started from this clear, operating part number this clear. This clear method. Last paragraph. Say, I am reading.
What is the direction?
Direction method this method. Thereafter, complete orders in the same. If the particular is eligible to be allocated to areas should be considered for development of the room in the mainly constructed portion at the whole vegetable market and pass on the under concern. If authorized as per the rules, the particular then approval orders may be passed there. Then when the order was communicated, management was started.
Where is the communication?
We have
Where is it communicated? Proof that it has been served. It has been received.
13 manner, have submitted the order.
How do I know?
Manner.
How do I know this?
This is received by the office of the.
Where is the receipt?
Yes, manner, in the top of the seal and just 13.
Issue notice making it returnable on 9th of January 2026. Madam, here they have put the executive officer as a contender. Just find out from the, because she's the executive officer of Bilasipara Municipal Board. As to what, as to whether the representation, as to whether the order has been complied with, because she is otherwise a government official. You won't issue notice for the time. It's an application filed alleging willful and deliberate violation to the order dated 9/12/2024, passed in deputation number 6554/2024, whereby a direction was issued consider the prayer made by the petitioner through his representation stated in 12/9/2024 and 28/10/2024. It is alleged by the petitioner that the said order was duly communicated on 16/12/2024 to the Executive Officer, Bilasipara Municipal Board, Bilasipara. However, the representation so submitted have not yet been disposed of. This court requests Ms. Yuda, the learned additional senior government advocate, to take instructions as to whether the order passed by this court dated 9/12/2024 in WPC number 6554/2024 have been complied with or not. A copy of the contempt petition be served upon her during the course of the day. The registry shall show her name in the cause list. Show the name of Ms. Yudas, additional senior government advocate, in the cause list. List the matter on 15th of December 2025. Or for motion.
So,
In the motion.
we can.
Yes,
Matter of significant time. At page 20. At page 20.
why are you taking so much of time?
We want to
The
withdraw,
case is bad.
we want to withdraw the withdrawal form of that. But it was 4 participants, one with above the minimum value, he went up, did not take. The rest 3, they cannot settle. So otherwise, will be academic system. We'll withdraw with the liberty, because if they settle again, we have to come. In this
What
circumstance,
liberty?
the liberty to challenge enhanced, because that remains. If this they cannot settle, obviously they cannot settle, be academic. But if they again go for enhanced,
So then is a fresh cause of action.
that's, that,
So then I'm not going to.
how many instructions? You should be there.
Mr. Esbonik, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. Taking into account the above, the instant writ petition stands closed on withdrawal. Mr. Ms. Yudas appears for the district administration and Ms. S. Sutia appears on behalf of the fishery department of the government.
Item 3. And present details are they have the volunteer available.
Huh?
Now they have appointed.
So you don't have any case.
Uh,
As of now, you don't have any case. The receiver has been appointed. Huh?
that.
Fight out all these things there before the receiver. Whatever may be, that is a different thing, but you are challenging the contents of a particular document. You raise all these disputes wherever it is possible, not here. What liberty? You file whatever you file, whatever you do. Without prejudice to assail the document. What is the document? The minutes, na? In any other proceedings, huh? Mr. J. Kolita, the learned counsel appearing on behalf of the petitioner, submits that the petitioner may be given the liberty. Submits that presently the tea garden in Cochin is under attachment and a receiver has been appointed by the Assam Tea Employees Provident Fund Organization. He further submits that taking into account the said, the petitioner herein would not like to proceed with the instant writ petition. However, at the same time, Mr. Kolita also submits that the withdrawal of the instant petition should be without prejudice to the petitioner to assail the minutes of the meeting dated 18/9/2025 before appropriate forum. So taking into account the above, the instant writ petition stands closed on withdrawal. Full. It is observed that the withdrawal of the instant writ petition shall not prejudice or preclude the petitioner to assail the communication minutes of the meeting dated 18/9/2025 before the appropriate forum.
Oh.
Yes, what is this?
Industry special incentive scheme 2020. Okay. Okay,
What?
the scheme is at page 46. Okay, as per the scheme, but there are some incentives because announced.
Madam, you appear in that matter, no? The earlier withdrawal.
Yes.
You thus appears for the district administration. What do you want here? Directing and commanding the respondents move specifically the finance IF department to refund the orthodox or special subsidy declared by ATS scheme that is for the period year to the petitioner and give full release.
The scheme had applied on time, but Lordship, what had happened that when I applied on time, there were some mistakes, so we submitted a revised application. There is a Lordship mandate under the scheme that you should apply within 31st of May. I had applied earlier before 31st of May, only some revised application was filed thereafter. So Lordship, I had obtained certificate from the district commissioner center as well as commissioner of justice and commerce. We say that my application was on time.
What is this type of papers? On the back side, there is printing out there.
But page 99, there was.
What is this type of papers? Huh?
At page 114, the Commissioner of Industries and Commerce have already written the letter to the Director, Ministry of Finance, that my application was not time barred and may be considered. Because Lordship, this is the nodal agency who has to approve my claim.
Yeah.
Claim has been
Yes,
verified.
yes, read it, 114.
See, the next page, 40 days, the next copy. 40 days, the next copy. Lordship, this will Lordship clarify the entire case, my Lordship. It is to be mentioned here that the unit has already applied under ATXS 2020, while so and so dated 9/4/2022. But while processing the claim application, the general manager, AICC Galgary, has returned the claim application to the commissionerate, stating that there is mismatch between quantity of steel claims and quantity on as per the return submitted by the T4. And same has been returned to the applicant on 13/4. According to the unit, had resubmitted the complete documents on 24/6/2023. So while resubmitting the required documents, a new application number has been generated in the portal, bearing number so and so. The same has been forwarded to General Manager, AICC Galgary on 24/6/2022 for reconciliation. The General Manager, AICC Galgary, recommended that eligible amount of subsidy in the portal on 15/7/2022 was forwarded to T-Board for cross verification and subsequently T-Board approved the proposal of the new number generated. And the same was approved and forwarded to the Department of Infrastructure, Finance, Government.
Now, what is this notification?
Now, Lordship, this is Lordship, that this scheme has not been Lordship, it is not that the scheme, they have left the scheme. They have extended the scheme. That is what I am showing, Lordship, that it is not that they have left the scheme. They must pay. The scheme has been Lordship extended for another period of time.
Where finance? No finance. Here's what you have to say. Respondent number? What do you say? You don't have instructions. Okay, you should notice making it returnable on 21st of January 2026. Ms. Udas accepts notice on behalf of the respondent number 1, 5, 6. Mr. S.K. Midi accepts notice on behalf of the respondent number 7. Finance?
Lordship,
Mr. So-and-so accepts notice on behalf of respondent number 2, 3, 4. Extra copies of the requisition be furnished by tomorrow, by Monday. The case of the petitioner herein is that in pursuance to policy, where is the policy? Policy, in pursuance to a scheme being Assam Tea Industry Special Incentive Scheme 2020, the petitioner applied for benefits by an application dated 9/4/2022. The said application, however, was returned to the petitioner in view of the mismatch between the quantity of orthodox tea claim and the quantity as per the e-returns received by the tea board. Thereupon, the petitioner again resubmitted on 24/6/2022. This application, upon resubmission, was given a fresh number in the portal. It is also the case of the petitioner that the General Manager DI and CC Udalguri had recommended that the petitioner was entitled to the eligible amount of subsidy in the portal on 15/7/2022, which was forwarded to the tea board for cross-verification on 19/7/2022. The further case of the petitioner is that the tea board approved the proposal of the new number generated on 5/9/2022. And the same was approved and forwarded to the Department of Infrastructure, Finance, Government of Assam by the Office of the Commissioner of Industries and Commerce, Assam on 5/9/2022 itself. However, the petitioner have not been granted the benefits of the scheme, and it is under such circumstances the present petition has been filed. The respondents are directed to bring on record their stand by filing the affidavits on or before 21st, it will issue notice making it returnable on 30/3/01, on or before 21st of January 2025/26. The petitioner thereupon shall be at liberty to file the reply. Non-payment,
Non-payment of.
how much?
5 lakhs, 5,700. Sir, page number 30 to 49 is half. And annexure B, 50 to 60, page number 58.
February delivery. February 16th, February returnable. 9th reply. Affidavit.
They.
Same type matter.
Same matter, same matter.
With the order,
Yes.
we have it on the same date.
Well,
To order. Case number to Bunai. The reference case number would change, huh?
good change.
And here also.
Reference case number 11.
11/1/2026 दिया से ये reference case number तो spotlight award date. Award dated same
Date is 25, 10,
25
10, 24.
25 10 it is 28 years. Huh? We are keeping the question of limitation delay in latches open. So you may in the meantime file an additional affidavit giving justification when the award was published and thereupon your knowledge. Because if you don't do it later on, you will have problem.
Hey.
Non-payment, where is the admission?
Page 52 matter. Here, if any other letter to the, to release the fund.
PWD. So we dispose it off. You verify and pay as per Tamsir Ali. What makes sense keeping it out here? If you say also, you'll have to verify. Don't you think so? You'll have to verify and verify within 1 month whether he's entitled and then put it in the chronological list. It makes no sense otherwise. Dispose of query, so and so April.
Bye.
What is this?
Complement but this major part. 2018, last communication is 2018, page 30. Yeah.
So you have made payment in 2019. Hello? You have issued notice. And returnable on, where is the person concerned? Mr. A. Ganguly. None appearing. None appears on behalf of the petitioner on call when the matter is taken up. List the matter for 4 weeks. I'm after vacation.
There.
And within for, the process for off
Huh?
under the exact one.
Offshop.
Off.
Oh,
What has happened is that the respondent number 6 is submitted document after the tender process was closed. So we had raised an objection, my lord. That is a page 190.
what document did they submit?
They did not submit the document as regards the land, then the market clearance and also the land review clearance. So as per the tender conditions clause 6.12, 6.15 and 6.16,
Where do I find those?
those documents may not be at page 33.
No, where is the tender condition?
This is the tender condition.
Page
Page 33.
33.
Yes.
Which are the conditions?
6.2.12. 6.2.15.
Copy of the document showing that the bidder's right title and interest on the proposed site or land. Copy of the, then which one?
6.2.50, market clearance
15. And
land revenue clearance, sir.
where?
6.2.16.
These were not submitted.
May not-
Then,
And they have returned my technical kit, but they are, as on date, they have not opened the financial kit. That's it. So.
return your technical bill. What?
Return my technical.
What? You have submitted.
I have submitted, but they have returned. But they have, as on date, they have not finalized the. Yes, that's all.
But there is no clear order of rejection of the technical bit, but it is not clear. If yet it has been rejected or. But I don't be fix it on Monday, I don't, I'll get proper instructions. What is the thing?
Your thing has been rejected.
They have returned on page 189. The 5 lakhs which are deposited, 624, that was returned. But there is no order as such.
And you've taken back
EMD refund. This is my best thing.
180,
Nine.
where,
EMD refund 22nd September 24.
where do I find it?
Last column one.
Transfer.
Last column, by transfer, EMD refund.
Means they have given it to somebody.
We have, as long as, we have also submitted the application at page 190, there is no response from there.
Oh. Why don't you give it by hand?
No, there is one letter, which they are sent to Steve Post.
Now, technically, you are competent. How do I say?
They have to take a decision, my lord.
So you mean to say they have not submitted any, this person have not submitted these three
Yes,
documents.
ma'am.
So he was technically incompetent, the
Yes,
private
ma'am. He's a
respondent.
invalid.
On the other hand, you submitted
Yes, ma'am.
and there is no technical evaluation being informed to
Yes,
you,
yes,
but you have got the EMD back.
yes, ma'am.
When
Monday, my lord.
I passed the stay, Intel,
Only day, ma'am.
Monday till Monday. Issue notice returnable on Monday is too early, on 3rd. No, events will fall with the liquor shop not operating for 2 days. Okay. Monday is too early because he has to give you copy today. You may also have to send it, making it returnable on 3rd of December 2025. Mr. Aibo Thakur accepts notice on behalf of the respondent numbers 1 to 5. For the present, this court is not inclined to issue notice upon the respondent number 6, which shall be done, which this court shall consider doing on the next date. The respondent with the district commissioner respondent number 3 had issued a notice inviting tender for grant of Indian-made foreign liquor retail off licenses in the district of Lakhimpur at the locations mentioned in the list of shops contained in the e-document. The petitioner, along with various other bidders, participated. It is a specific case of the petitioner that the respondent number 6 have not provided the documents enlisted at clause number 6.2.12, 6.2.15, and 6.2.16. Under such circumstances, it is the contention of the petitioner that the respondent number 6 was not eligible, was not technically competent, technically responsive. On the other hand, it is also Mr. S. Count, the learned counsel appearing on behalf of the petitioner, submits that without any rhyme or reason, the petitioner have been refunded the earnest money deposit, which the petitioner could learn when an amount of rupees 5 lakhs was refunded on 22nd of September 2000. What? What is the date?
24.
You're coming now.
So, but even then I have submitted representation.
No stay. Have it after vacation. You can wait up till so much. Then, this is a case for dismissal. You get the instruction by 2 o'clock. I think we should dismiss it right away.
Or I don't think I need to use,
No. What do you call, there's a term like sleeping ducks. Australia does not Something, we'll have it at 2. Get your instructions, what is that? No, we filmed it after vacation. When the council is not present, and otherwise you are also a very busy council, you may be very busy in many other matters. So taking into account that you are very busy, I have accommodated it well without fixing a date after vacation. For your, here your friend has left.
Can it be taken up, on any date, I'm not asking. Any date.
Why what date? I've said after vacation, so ask him after 4 weeks. So why? Motion, first of all, you have to satisfy why in 2017-18 matter, you are filing the petition in 2025. Last payment you got in the year 2019. You woke up after 6 years.
No, there are some grounds for.
What grounds?
Well, there was this is a partnership, the partners had passed
What?
away. The original partners passed away during the course of the matter. And, well, thereafter, well, the firm has to be reconstituted. In fact, it's a family firm, fine. Both the parents.
But does it mean that you one fine morning come to the High Court
No, well, there is.
after 6 years?
All the documents were lost, the managing partners passed away, everything was here. Today, well, as of.
So go there before the civil court.
In fact, that's.
No, I'm not satisfied. You give it to me. Let me dismiss it right away here. One non-payment of dues I have not dismissed today.
His wife-
Let me dismiss it right away. We don't require him.
And then
Yeah.
the real life, and extend the communication also of 2023.
Not 23 communication does not make a sense. You got the last payment in 2019.
So that, yeah.
So therefore, why after 6 years?
So actually what is happening-
You cannot just wake up one fine morning and look, yeah, I'm so and so. And that too, you are an MSME. It's a very dangerous thing. You coming up with a certificate of MSME means it will have far-reaching consequences.
Those we will of course. not-
No, these are far-reaching. I ask some order for payment, then the next moment you come up with another issue. Then look here, interest. I am a registered firm, give me interest.
No, that was such a.
No case.
Unfortunately, that was the both the partners, the managing partners, our parents, they were the partners, they expired. That is the difficulty. This is a claim, which is actually admitted and in fact part payment was made. And here, there is no even question of completion because this is supply order. So I supply, we pay. There is no ground that they would come up with, that, I have, there is some, effect in the quality of sugar. The supply order, some supply, that's true.
Where is the admission?
The admission, by way of payment, because all the bank accounts.
No.
Were run by the previous, partners.
Nothing is there. No admission, nothing. Go there.
Yes, admission will be.
One fine morning, you wake up in the year, and that too, you have not enclosed the other one.
No, here was one.
There are two representations. Where is the first one?
Representation was, the completion certificate and the representation is of 2000.
Where is the completion certificate?
Completion certificate, is at page 36.
Huh?
Page 36.
8?
36. In fact, there it is actually not a question of completion, but a question of.
Page
delivery.
32 is a tax invoice.
No, 36.
36.
36. And starting from, this is,
Where is it said that some payment is due?
no. Payment is due, this, here, at column number
There is
13.
no date also.
Date is not given.
Then date of completion is 27/1/2018.
Yes.
You
No,
cannot
it's a
come
supply.
out here. No, I think this we dismiss it.
It's a supply,
No,
it's a supply of goods, and they have already made the party.
the work is what supply, nothing is there. It is,
Supply of RCC class, this is.
go and prove all these things before the trial.
We got, should kindly have page 29 onward, the tax invoice which were received.
Division bench may have help you. I dismiss. Okay, yeah, this is an application heard Mr. So and so, the learned counsel appearing on behalf of the petitioner, and Mr. N. Upadhyay, the learned standing counsel of the irrigation department. The petitioner herein have approached this court seeking a direction upon the respondent irrigation department to pay to the petitioner an outstanding amount of rupees 9,60,170 on the basis that the said bills have been duly admitted. It is the case of the petitioner that the petitioner was issued a work order for supply of RCC Hume pipe with collar for CAD works as BIS for the year 2017-18. The said work order was issued on 4/1/2018. The materials on record further reveal that the said work was completed on 27/1/2018. So where is the work order?
Because work order, there are three work orders, connection 4, 5 and 6. So there is 4/1/2018, pages 20. Pages 20.
It is also the case of the petitioner that certain amounts, an amount of
10,000
rupees 8,10,705 have been made to the petitioner sometime in the year 2019. However, there is a balance of rupees 9,60,170. There is nothing, this court have duly perused the materials on record and do not find any good justification as to why the petitioner has approached this court after a period of 6 years from the date on which the petitioner was entitled to the amount. তাৰপিছত Mr. N. Mukherjee only এইখিনি লিখি এইটো কৰি dismiss liberty civil courts. Prejudice without prejudice and shall not preclude or prejudice the petitioner to approach.
11.
What?
And participated in the tender process in on page 34.
Where is the tender?
Tender start from page 34. Member.
34. Security manpower service, healthcare, unarmed security guard. Then you applied.
I fulfill all the criteria. My lord. Page 36, which is regarding the document pertaining to the financial eligibility.
What are
I like
those?
to write point number 1, the minimum average annual financial turnover of the bidder during the last 3 years ending 31st March of the previous financial year will be as indicated above in the bid document. As per the bid document, financial requirement is 5 crores. 5 crores. I have the financial credibility of around 4 crores. I feel fulfill that criteria. Second line, my lord, it says documentary evidence in the form of certificate, audited balance sheet of relevant period, or if one or is important, whether or a certificate from the chartered accountant of the cost accountant indicating the turnover details. I have submitted both.
May I point out one thing, my lord, he has challenged the rejection of his bid, my lord. Now, my lord, the work order has been issued in favor of the party, my lord.
Has he made those people a party?
He has been made a party, but
Okay.
his work order has not been challenged, my lord. It has been awarded. So basically, this petition has become infrastructure.
Anyways,
Yes, my lord. Actually, documents will be submit what is the certified audited balance sheet or certified certificate from the chartered accountant. I submitted both the documents, my lord, in the online portal. But, and my lord, in the page 35, is the instruction for bidder. ITP document.
yes.
Point number 4, technical bid.
which consists of the supporting document as proof of meeting all eligibility criteria. Last point, my lord, point number N. Here they mention that certificate of chartered accountant of average turnover, annual turnover of so and so. Here, my lord, in the ITB, they change the criteria. As per the NIT, two documents need to be submitted, either or. Here, they have only mentioned that certificate of chartered accountant. But they have deleted the point, certified audited balance sheet, my lord.
Huh?
In this point number N.
So they've given the certificate of the chartered accountant about the average annual turnover.
Annual turnover, that's what is there, but I submitted both the,
What do both the documents means?
one is by a certified audited balance sheet and certificate by the chartered accountant.
Then
When I uploaded both the documents, in case of certificate from the chartered accountant, there is a mistake on our part, where UBIN number is missing. UBIN number in the case certificate.
what?
UBIN number, unit documentary identification number is missing. In my submission, that is in page 67. That immediately
Page 60.
7.
Ah,
As per the NIP criteria, I submitted this one, my lord. Yes, UPI number is missing. Subsequently, I uploaded a press,
72.
press document, my lord, yes, my lord, but that document has been rejected by the respondent. That is on page 68. Page 68, they are saying that technical specification mismatch as per the detail indicated in the comment. Comment is usually PIN number on the turnover certificate. They are mentioning usually, but it is missing by the, but my lord, I have already submitted the certified audited balance sheet. This point has been not considered. On the basis of PIN number, they have rejected my bid. Thereafter, I submitted my representation, my lord. That is at page 70.
7.
708. Or my lord, tally is 74. Here we mention, my lord, we are submitting the latest year certificate for annual turnover for 3 years, consecutive year, signed and sealed by the chartered accountant CA with an edit PIN number for your kind review and approval. In my other documents are very, that is the audited balance sheet, right? Now, on 1st 11/2025, they have rejected my representation, mentioning that bidder failed to submit the mandatory audited financial certificate. Here they edit the word mandatory audited financial certificate. Because when the certificate is issued by the CA, it is not required to be audited. Its certificate is itself a valid certificate. Audited certificate means an audited balance sheet, by law. But they have rejected on the ground that bidder failed to submit mandatory audited financial certificate. By the bid submission deadline 2024-10-25. Bid submission that is 24-10-25, but we have submitted before that there is no violation matter. The document was later furnished on 30-10-25. It is not with the document, only the verification matter. And as per the tender condition, they have referred two goods method. As per the tender condition, rule 173 of the General Finance Rule 2017. Post deadline submission of essential document altering the substance of the bid.
Mr. Counsel. Kindly come to page 45. 45.
Yes.
4N. 4N. Read it properly. Certificate of the chartered accountant about average annual turnover,
Is better.
rupees 5 crores or above, of the bidder during the last 3 financial years. 2022, there's 23, 2023, there's 24, and 2024, there's 25. As per Annexure 5. Now kindly come to page 62. UDI,
Yes, right.
it is there.
Yes, right.
So your certificate which is there is not in consonance with that. So therefore they rejected it. What is wrong?
No, no, my lord. The initiative and as per notice inviting tender, there is a two documents. Either or, I have submitted minor certified audited balance, that is still there. It is failing. They could have considered that.
No, in the GM portal, there is one circular whereby this will follow. The instruction to the bidder shall follow.
Follow.
There's a GM portal. Where is that?
But
That I have brought in. And in that part is that might not fail producing certificate, where of course UDI was put out, and false filed.
Huh?
No, false UDI matter.
No, there is no UDI. You have to read it, Mr. Bora.
Yes, ma'am.
First certificate did not contain UDI.
Delete UDI.
No, there is no UDI. No UDI and invalid is different. No? There is no UDI. So it is not as per Annexure 5. Now, in view of this, I think 2315 also, it cannot be permitted to bring on record the turnover certificate. And there is a finance advisory in that regard. Dated, I'll give you the date. T12/2024. Finance advisory.
though if their number is missing, it doesn't mean that there is a material evidence in the big progress we have. Yes, my God, I like to submit one judgment on that my God. It is 1981 3 SME 273 voter street operation. It is a case number 6 regarding my submission is that it is like a clerical mistake or you cannot be a material ABS. Paragraph 6 minor. It is true that it is submitted in tender accompanied by a check of United Bank of India and not of the State Bank of India, for the tender notice was not open returned. But the question is as to whether the state non-compliance deprives the detailed locomotive cost of the authority to accept the bid. As a matter of general proposition, it cannot be held that an authority waiting tender is bound to give effect to every terms mentioned in the notice. Even meticulous details.
That case.
But my case is already confirmed because I have submitted audited balance sheet backup. Audited balance sheet, it is there. I don't fix it.
That case again.
Better,
The same has already come up. I think it is also there in the tender itself. Is it there in the tender?
Sir, I have already submitted as per the requirement. I have fulfilled all the criteria of the. And my submission is that the instructor cannot override my lord an idea.
What cannot override?
Whether instruction to bigger that rules. And my submission is that as per notice of invitation, I have submitted my lord. I have fulfilled all the criteria. And my lord, they have rejected my this one, my lord, my parents, my lord. Each way. I have to get for it. And they rejected under rule 23, 7. They rejected my under rule 27 or 23, 7 of the account of this procurement rules 2025. I like to refer that one.
Now kindly come to page 44. Read the top one further.
Further, if any seller has any objection or defense against this additional clause or otherwise in any aspect of this deed, they can raise their representation against the same by filling the representation window provided in the deed details filed to the seller next court after lodging it as the seller within 4 days of the deed publication of CDL. Buyer is simply bound to reply in all such representations and would not be allowed to open which if he failed to reply to such representations. Yes, sir.
So here, this is after this. It additional terms and conditions.
Yes.
Now they have incorporated certain additional terms and conditions. You say these additional terms and conditions is conflict with the buyer's agreement, the GEM portal. Now the GEM portal gives you an opportunity. You raise that.
Sir, I have raised that one, my lord, on 30/10/2025, that's a case of-
Not that. This was issued on 13/10, isn't it?
It is issued on 13/10, but it is.
1/3.
but it is- Original
3/10. So within 4 days, you have to therefore take notice of that.
My lord, it is based on 24th October, my lord. 24th October. It was okay, whereby I will inform that I might be disputed. Thereafter.
No. If there is a discrepancy between the GEM portal and the ATC, you are to report it within 4 days. Did you report that?
Then my lord, I have to take. my lord, take that.
Better you withdraw and file a fresh one challenging the work order also. Don't you think so? If you had a good case, I would have passed that order, passed the stay, irrespective of the work order being challenged or not. But you don't have a case. And Mr. Bora, next time when you appear, get that circular of the GEM as well as the 2012-2024.
I have noted that.
It's not for this court to help you out.
Liberty. Liberty.
Oh, yes. The petitioner herein have essayed the actions of the part of the respondent authorities in rejecting the technical bid of the petitioner in connection with the NIT dated 3/10/2025 in respect of the work of inverted comma security manpower service bracket version 2.0 bracket close dash healthcare semicolon unarmed security guard comma security manpower service bracket version 2.0 bracket close dash healthcare security service supervisor comma security manpower service bracket version 2.0 bracket close dash healthcare semicolon ASO. Mr. DP Bora, appearing on behalf of the Health and Family Welfare Department, Health, na?
Yes, sir.
Submits that in the meantime, a work order has already been issued to the respondent number
Respondent number, my lord.
7 on 27/11/2025. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the petitioner would be well advised to withdraw the instant writ petition and file a fresh writ petition challenging the work order also. A copy of the work order has also been furnished to him. Have you got it? Okay, take it, give it to him. During the course of the hearing, taking into account the above, the instant writ petition stands closed on withdrawal. However, liberty is given to the petitioner to refile by challenging the work order, including the challenges made in the instant petition. Well, already made in the instant petition. Yes, what is this? At last, you have changed your subject, respondent, from ONGC to oil. What is this?
The sector of one LPG transportation by road with a state of Assam Meghalaya. Invited for 400 trucks. And I being eligible, I mean, in fact, my one of my truck is presently running there in pursuit to the last contract. And I being eligible, I participated. I was technically aware. Then there is a query that the low capacity carried as stated in the RC and in the PESO license. PESO is the petroleum explosive and safety organization, like that, there is a difference of 70 cases. In the RC, it is 7,500 cases, and in the PESO license, it's 7,570. Then I gave it affidavit stating that this error will be corrected, and while during inspection, by the time of inspection, this I will show you the correct PESO license. This is a technical error. So accordingly, that was accepted, and my bill was considered for the financial state, and my bill was open. And they found me to be L1 along with many others. And there is a procedure for allocating because they have the 400 drive. Now they have been allocating the other L1s on time to time basis, but my one was given the LOA. So I repeatedly requested that what is the reason for not. Then there is a one line email stating your draft is not suitable for issuance of LOA. I then immediately responded asking as to what is the reason, because I have given my clarification, but accepted the clarification. Also, by the time I have received the corrected system license, and till that time you have not conducted the inspection of my draft. And also then how did you find what is the basis for the or the reason for your conclusion? Then they have not responded. Then I give the review test, and also that was not replied to. So in that actual circumstances, I will show your lordship. Now, in this lordship, my limited prayer is, I want this for a reason for the decision. The reason your lordship is your lordship is the page 179. Draft did not qualify for LOA. My bid is still accepted, my bid is. Immediately.
Yes. Why have you not provided the reasons?
Instructions final. There is much days before Roshi. Instruction minor. What happened, my lord? There is the 11 week, and the other than there was one week time. In the land, there is requirement. The we might have in guidelines. Then, an opportunity was given to the petitioner to correct it. And within the time they could not correct it. In fact, my lord, if your worship finally comes to the, my lord, instruction. Paragraph 2, my lord. RCM PESO document has been submitted by the Managuti Bora, these things. What propagation was assessed, however, during evaluation, the submitted page was found in RLW and CLW in the RC mode as these then the license capacity declared by the PESO. Then other relevant provision has been paid. Then your worship may come to the next stage, my lord. My lord, clause 1. The not fulfilling minimum qualification criteria respecting the tender documents. It is further submitted that although the petitioner was liable for not meeting the minimum criteria, the one-time opportunity with a fixed deadline was provided figures uniformly across all tenders of the 3 ounces in the interest of fairness to maximize participation to rectify the discrepancies. Accordingly, a courier with a fixed timeline of 4 days was issued to such bidders to explain that these submitted documents were not in conformity with the tender conditions. Bidders were advised to submit documents strictly in accordance with the stipulated conditions within the prescribed guideline. Building with the evaluation of the ability of the of the document. And my lord, that was accepted after within 2025. I think that time my lord would not be given. My lord, may I also throw you also the petition? So at that point, another petition has been filed, challenging the same.
Another representation.
Another petition, my lord, there is an interim order taken. Can I place that order, my lord?
Who has filed?
Some other party, my lord, the participant in the, my lord, the same kind of process. The interim prayer. Last paragraph. This is order on the other court. considering the submission of the learned counsel for the respondent that LOI has already been issued for 316 tracts. And also considering the submission of the learned counsel for the petitioner that if there exists vacancy, the same shall be kept reserved in the returnable day. It is provided that if all the requirements are not made, as of today, the respondent authorities are able to access, accommodate against the existing requirements if there is any vacancy. Now, my lord, my instruction is that, my lord, some LOIs have been cancelled and therefore there are some vacancies and my lord, the petitioner has offered only one tract. Petitioner has-
But the question is, I don't want to employ, ask you to do anything. If you want to do it. There are many ways it can be done. I can very well say that the reason assigned in the order
is not.
or disposing the petition, representation
Is not.
is laconic. And as such, it doesn't have anything. For which I set aside for reconsideration of the representation, then you consider it. If you find, because as of now, he has corrected it.
Is not right.
You also, the reason is you also need a handle to give it to him.
So,
Isn't it? The handle I should give it to you. How do I, this is how I have to set aside that aspect. Saying that there is no reasons. However, to consider if you can and consider afresh, taking into account that as of now, the fault was not his, fault was of the statutory authority. So you consider that.
yeah.
I think that would help him out. Heard Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. M.K. Chaudhary, the learned senior counsel, assisted by so and so, appears on behalf of the respondent numbers 1 to 6. Huh? Yeah, 1, 2, 1, 2, and 3, 5, and 6. Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, submits that the petitioner is not inclined to proceed in the present petition against the respondent number 4. He therefore submits that the name of the respondent number 4 may be struck off. Taking into account the above, the name of the respondent number 4 is struck off. The counsel appearing on behalf of the petitioner and struck off. And the respondent numbers 5 and 6 arrayed in the instant writ petition shall be renumbered as respondent number 4 and 5. The counsel for the petitioner is directed to file a fresh memo of parties for the registry of this court by Monday. And the registry shall thereupon make necessary. You can file it today. If you can file it today, then it's okay. Otherwise, what will happen? You won't get the order till Tuesday. Given the liberty to, is directed to file a fresh memo of parties before the registry of this court in terms with the instant order. And the registry shall make necessary correction of the cause title as well as update in the CIS. Taking into account the dispute involved, taking into account the issue which is issued and the limited submissions so made by the learned counsel appearing on behalf of the petitioner, this court issues rule returnable forthwith. The case of the petitioner herein is that the petitioner is in the business of carries on the business of providing transportation of bulk LPG. A notice inviting tender, e-tender, was issued on 1/3/2025 under a two-bid system for bulk LPG transportation contract by road for the state of Assam and Meghalaya for a period of 5 years. The estimated truck requirement for the state of Assam and Meghalaya, bracket equivalent to 7 metric ton capacity, was stated in the tender to be 400. The petitioner has one LPG bulk tanker vehicle, which was manufactured in the year 2019. In view of the therefore, pursuant to the notice inviting e-tender, the petitioner submitted the bid. It is the case of the petitioner that while carrying out the technical evaluation, it was found that there was a difference between the registered laden weight, bracket RLW, oblique gross vehicle weight, bracket GVW, and the ULV and the unladen weight, bracket ULV, in the registration certificate vis-a-vis the PESO license. PESO full form? What is PESO full form?
Petroleum and Explosive Safety Organization license, page 155.
Page
155 and 156. 155 and
55. PESO license full form.
at the top of the version. Petroleum and Explosive.
Petroleum and Explosive Safety Organization license. This aspect was pointed out to the petitioner, and thereupon the petitioner approached the concerned. Which one got corrected? The PESO. Had thereupon the petitioner approached the concerned PESO organization, the concerned authority in the Petroleum and Explosive Safety Organization for rectification. It is the further case of the petitioner that the same was rectified on
10/10/25.
10/10,
Yes, 183.
was rectified on 10/10/2025. Thereby, the
Next week. 7.5. 184.
thereby
The price carrying capacity comes to 7.5.
the gross vehicle weight was corrected in terms with the registration certificate, isn't it?
Load carrying capacity,
Huh?
load carrying.
You say at paragraph 12, otherwise. You. Load carrying,
Base is 180, because the difference gives the load carrying capacity,
okay, the load carrying capacity,
180 per hour.
where is that?
Column H. Column H.
The load carrying capacity was corrected and made in, corrected in terms with the registration certificate. It is the further case of the petitioner that in the meantime, neither the letter of acceptance had been issued to the petitioner, nor any further steps were taken. Though where you have been informed that you have been technically qualified,
Page 167.
though
168, serial number 320.
Huh?
168, serial number 320.
158.
68.
Though the petitioner's technical bid was admitted and was sent to for price and sent for price evaluation. And the petitioner was also evaluated as L1 along with various other bidders. The representation so submitted by the petitioner on, what is your date?
19 September, page 172.
On 19 September.
172 euro.
Nineteenth or 21st?
21st, print out taken. 19.
What?
19.
No.
Below 9, Manabora.
On 19th of September 2025.
On top of 19 September.
However, was rejected by the concerned respondent authorities with the following, with a one-line observation by an email dated, where is that?
Page 179.
79.
179.
Email dated
Third of
3/10/2025. The email reads as follows, inverted comma, trust did not qualify for LOA issuance. The petitioner thereupon submitted a representation on 21
on third, it's a page 180.
on 3/10/2025 itself. Seeking reasons as to why the letter of acceptance cannot be issued to the petitioner. The respondents, however, have not replied to the same, for which the petitioner had issued a legal notice on 24/10/2025. The The petitioner's further case is that in spite of the legal notice, the respondents have not disclosed the reason for which they presented petition. Mr. M.K. Chaudhary, the learned counsel, senior counsel appearing on behalf of the respondents, have placed before this court certain instructions to the effect that in terms with clause 1(3) of chapter 2, it is required that the trucks of the notice inviting tender, it is required that the trucks quoted must have a valid PESO license as on the original closing date of the tender. The difference in the registered laden weight and the unladen weight in the RC book must not be less than the license capacity declared by the PESO. Mr. M.K. Chaudhary, the learned counsel, senior counsel, submitted that though the statutory authority though the organization, that is the PESO full naam to likhi, had subsequently corrected the license and license in terms with the registration certificate. But as on the date on which the bid was submitted, the said license was not, the said license issued by the PESO authorities was not in conformity with the registration certificate. This court have duly, in addition to that, this court during the course of the hearing inquired with Mr. M.K. Chaudhary, the learned senior counsel appearing on behalf of the respondents, as to whether the requirement for which the notice and inviting tender have been issued have been fulfilled in the meantime by issuance of by issuance of work orders. Mr. M.K. Chaudhary, the learned senior counsel, upon being instructed by his assisting counsel, submitted that there has been the respondent, IOCL, still requires more trucks in view of the fact that various letter of acceptance which were issued have been rejected and cancelled. In the backdrop of the above, this court have also heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From the perusal of the materials on record, it is seen that the petitioner during the course of the technical evaluation were informed about the discrepancy in the carrying capacity stated in the PESO license vis-a-vis the registration certificate. The petitioner thereupon approached the PESO authorities And the license was and the carrying capacity of the petitioners of the capacity in the PESO license was rectified in terms with the registration certificate. The record further reveals that in the meantime, that the said corrected certificate was submitted.
That's informed.
Informed. The said corrected certificate, the fact of correction was duly informed. And thereupon, the petitioner was, technical bid was admitted. And the price bid was also evaluated, wherein the petitioner was found to be L1. This court also takes note of that the petitioner had submitted a representation on 19, na?
Yes.
On 19/9/2025, seeking reasons as to why the petitioner had not been issued the letter of acceptance. The respondent authorities, instead of giving due reasons, have just mentioned, have replied that the petitioners was not qualified for LOA issuance. In the opinion of this court, that the respondent authorities, being a state within the meaning of Article 12 of the Constitution, ought to have provided due reasons. More so when, after due information about the correction, the petitioner's technical bid was admitted and the price bid was opened. It is also seen that that the petitioner thereupon submitted a legal notice also, which the respondents have not cared to reply. Taking into account the above, in view of the above facts and circumstances, this court therefore disposes of the instant with petition with the following observations and directions. Number one, the reply dated 3/10/2025 by the Deepak Singh Yadav.
Yes, respondent number 4.
That's one number 4 we have
Five,
struck him
five.
out.
Is the respondent number 5?
What is he? Manager
Is the,
LPS.
yes.
Huh?
Yes.
The reply given by the manager LPS dated 3/10/2025, being devoid of any reasons. The same email, the same reply is interfered with. Number 2, this court directs the respondent authorities, and more particularly the respondent number 3, to reconsider. No, respondent number 3 is tendering authority. How can they consider? I think we should give it to the CGM.
Go back to my lord.
Number 6. Number 6.
Yes, fine. Okay, the second option.
Directs the respondent number 6.
But after the correction, you will assume of 5 minor. After the correction.
Oh, 5. The respondent number 5, that is the Chief General Manager (LPG) of the Indian Oil Corporation, to consider the representation submitted by the petitioner on 19/9/2025 afresh, along with the legal notice issued on 24/10/2025. The same shall be done within a period of 15 days from the date a certified copy of the present order is served upon the respondent number 5. Now, next. It is for the sake of clarity, this court finds it relevant to observe that this court have not entered into the aspect as regards the legality, a respect pertaining to as to whether the respondents are required to issue the letter of issue acceptance to the petitioner. It shall be within the authority of the respondent authorities to take up on. Did I put that line or not?
But the link is there, madam.
Huh?
The petitioner wrote to the authorities personally, and madam was explained, and he was asked to carry certain documents. The week may also have to appear before the authorities with the relevant documents. Documents are madam from the RC and the madam personal license, character personal license.
You want to submit it? Yeah. Should I direct it? I think I leave it to you.
Yes.
You consider. Should I put that last paragraph or not? That I have not touched anything.
Let that be there.
Let it be there. Because the reason is tomorrow if you don't give him, he gets a liberty. But if I otherwise don't say, he won't get the liberty to again come. And we encourage Mr. R. Sharma to come again and again. Earlier he was troubling ONGC, now he's troubling you. About health. Yes, Mr. Goswami.
The pharma manufacturing company, the pharmaceutical manufacturing company. Essentially, we have come for your lordships, saying the order at page 210, which is the order of blacklisting. Now, good lordship, kindly have a look at. There was independent.
Yes.
Have a previous statement. There was a night which had called for suppliers from across the country to be panel as suppliers. In that, we also responded and we have been panel to supply 25 products. In 25 products everywhere. It's just that we had LOA. Now, these products are to be supplied by us across the state in 7 districts. The issue today is only with respect to this. And the issue is only with respect to 4 drugs. The total purchase order, which Dr. will find, the total value of the order that has been given to us is at page 115. Okay, Dr. It is 161. I'm so sorry, Dr. The total value of the order across 115 purchase orders is 17 crores, of which we have supplied pending supplies of 69 lakhs.
But this is for many.
That's what I'm saying. Out of this, 69 lakhs of supplies were made. Today, the dispute is with respect to supply. We have supplied 16 crores or lakhs of medicines. But today, the dispute between is of 31,000. It's a shortage of supply of 31,000 rupees of medicines to one district that I have now been debarred for 3 years.
Where is the show cause?
Yes. The show cause notice is that page. No, that is what. There was no show cause immediately preceding this blacklisting. There was a show cause which was given to us, which is at page 181. Page 181. But after that show cause, we replied, and after that, please give us some extension. So what I'm trying to say is immediately preceding this blacklisting, there was no show cause. And that is an admitted fact.
Well, what do you say about 181 page, the last paragraph?
Last paragraph. Yes, therefore submit a relevant reply. We reply. The reply is in the next page.
No, hence in the greater public interest.
Of page.
181.
Yes, hence in the greater public interest, you are asked to show cause as to why your products should not be debarred as per referred pending clauses of the tender. That is clause 5, tender and terms, conditions, subclause H, debarred and blacklisting for failure in execution of supply, non-supply, default in supply. Now, if lordship, before we proceed, we need to examine what is clause H of the NI, the blacklisting clause. Kindly lordship, come to page 60.
You can also find the same thing out there in the, we got the letter of intent. There will be a clause out there, no?
The page 60. This is what they are referring to. May I place it questions? Page 60, clause H,
Page 153.
page,
153.
I'm reading for the NIT, page 60,
Read from the letter of intent.
page 153.
154 starts.
Yes. Nature of default. In case one batch or two batches of a particular item supplied by a firm fail the quality test, that doesn't apply to us.
No, in case there is a delay, 154.
Debarment, blacklisting for failure in execution of supply, non-supply, default in supply.
In case there is a delay,
Yes, that is what I'm reading out. In case there is a delay in delivery beyond the stipulated period as mentioned in the purchase order, there shall be a penal deduction of 2.5% of the value of delayed goods per week of delay or part thereof, subject to a maximum of 10% of the total order value. Once the maximum price reduction is reached, termination of the purchase order will be considered. Termination of the purchase order will be of blacks.
then again,
Yes. In case alternative purchase is made, the incremental additional cost if any incurred for such purchase shall be recovered from the default. Then lordship will come through the clause that they have now tried to enforce. Debarment, blacklisting or failure in execution of supply, non-supply, default in supply. In case there are two things, one is product debarment. That is one, H1. In case of non-supply or incomplete supply, that is less than 90% of the total ordered quantity by the approved manufacturer importer firm within agreed delivery period, including the delay penalty period or such extended delivery period, then the concerned rate contract shall be cancelled and the manufacturer importer shall be debarred for participating in any pay or by the authority for 5 years from the debarment of that item. So this is item. Now, lordships, the next one. In case the manufacturer importer firm supply 90% or more of the ordered quantity, but fails to supply the entire quantity within the allowed delivery period, then the firm shall be levied a penalty at 10% of the value of the short supplied item and shall be adjusted against the payment of supply. So next, it doesn't come, so blacklisting doesn't arise here, the next part. Now, lordship, what has been done is, we as a firm have been debarred, that is what they were. The firm shall be blacklisted and debarred from participating in any tender by the TIA or procuring agency for 3 years if the company is debarred for all the items where it has RC rate contract for less than 3 items or at least 3 items where it holds rate contract for more than or equal to 3 items. Now, lordships, we have prepared a chart for lordships consideration because here what is necessary is only with respect to issue.
now therefore, in that context,
Yes.
Let us read page 181.
Take one. Here. Hence, in greater public interest, you are asked to show cause why your product should not be debarred as per the record panel clauses of the tender, that is clause 5, terms and conditions, clause 8, debarment and blacklisting for failure in execution of supply, non-supply, default in supply. Please note that if 3 of your empaneled products will be debarred, for which your company failed to execute the desired supply, it will result in the debarment of your company for a period of 3 years. Then they expect the penal clause.
Now, where is the contents? What is the allegation?
That is what I'm. The allegation is that we have not supplied food products, only to dish food. There is a shortage of supply.
So as you say, it is some 17 or 16 crores,
Yes.
of which you have not supplied for around 31,000.
Yes.
So that won't constitute 90%.
Precisely, therefore the Lordship will have this chart for Lordship's convenience. They just hand it over.
No, therefore, that allegation has to be done for the purpose of firm debarment. Isn't it?
And even otherwise, Lordship, let us talk about proportionally this, which Lordship will also have to see. Because blacklisting is a huge civil consequence.
Where all the consignees have risk. Can you see your reply at 184, paragraph 2?
Yes, Lordship. Yes. We are saying that we could not supply to the
Have received their goods and that we are falling short of 100% and less than 90% only because of.
It was there at that date. Thereafter, we supplied whatever was shortfall. So today, as per us, there is only one medicine remains to be supplied, which admittedly we couldn't because of there was a lack of stock.
So there you have been page 185.
Yes, gotcha.
Time was granted.
Yes. The
On-
final extension of time is at page 206. If Lordship will see,
15.9.
206 is the final extension. Where they said, whatever remains, please supply it within the next 7 days. And we actually supplied within the next 7 days. Except for one item.
So what is the value there?
Yes. That value has $13,971 worth of drugs would be actually full supply. Lordship will see, we have prepared 2 charts. One is as per their records and one is what we claim. Even if we go by their records, the shortage is only 30,445. And prior.
What is this?
I look at this. That's not.
The second one?
Lordship, the bottom is 13,000 or 30,000?
13,000.
Yes. This is what we claim is the shortage. And even if we go by their figures, let us go by their figures, which is the other chart. This is what they claim has not been supplied. The total amount of, the total is 30,000.
But it's less than 90.
Can't be less than nine,
Huh?
can't be less than nine.
You, from your thing, it is given out here in their thing, 30,000. 75% supply made in percentage, 82,
This is
88.
their figure. And these are our figures, because there is a bona fide dispute. As per us, only one product is less than nine. Rest is all above nine. And Lordship, just one page I'd like to draw your Lordship's attention to this. Much before the final extension was given, kindly come to page 201. We had sent an email to them saying that we have now supplied, if I may just place this paper. This is an email of 20th of October 2025. This, dear sir, this is with reference to the trading bill. We would like to inform you that we have dispatched the goods to the respective warehouses as detailed mentioned below. And the first three pertains to T2, and we have annexed the GST invoices with customer. 203, 204, 205, but the GST invoices pertaining to these supplies, which they claim were short for. And this is also reflected in that.
Okay, Mr. Usami, we do one thing, we issue them a short notice, ask them to file their reply. And we finish it off before vacation. Because anyways, we can't issue an interim direction now. No,
My
I can't.
request is not.
No, because it won't be proper to grant the interim, because interim direction will have far-reaching consequences. Therefore, we'll have it on 11th of December.
Not be kind of because we are actually placing, we are not being able to participate.
You could wait from 17/11 if you're going on. We are today on 28. 11 days here and 11 days there. I'll give them 7 days. You see, this matter has to be finally disposed of.
Yes,
Don't worry, we'll have it on 11th at 2 p.m. We'll take it up for final disposal.
but there are trucks waiting outside the warehouses of warehouse. What will happen? The medicine can be. There are emails we have annexed from those.
No, you have only 13,000 left.
No, the other supplies have also been stopped. Because once you blacklist, future supplies also cannot be accepted. So there are emails of the state government warehouses that truckloads full of medicines are waiting outside the godown.
Very good.
Yes, please have it. Please come to page 222.
Page?
Page 221.
Yes.
Yes, it's not.
And these are invoice dated on so and so,
Yes.
long time back.
So no, these are 25.
Where have you mentioned that the truckloads are, no, where have you mentioned about the truckloads?
Yes. Paragraph 27.
Huh?
Like you said.
No, where have you mentioned that allow me to supply those which are already being there?
Yes.
What happens, Mr. Bora, as regards those invoices which you have issued for supply? Already issued prior to the from the government. What happened?
My lord, the final position is the final development notice, my lord. As per the development notice, at page 206, my lord, that is the final position at page 209. Because that isn't, my lord.
Hmm?
So these are the quantities left to be supplied, my lord.
Which is?
Page 209, my lord. Regarding other medicines, they have claimed that they have supplied more than 90%.
In fact, it is their data I'm relying on.
No, it is not disputed, but it is disputed, my lord. They are saying that after issuance of the last extension notice, my lord, after issuance of the last extension notice, now they have submitted one sheet saying that, my lord, they have completed more in respect of one item 100% and in respect of item more than
No, in respect of one item 100% and in respect of.
But if you say, Mr. Goswami, 209 is exactly the chart which is pertaining to 30,000. This is the chart.
Yes, sir, that is their chance.
No, you say as per you it is much less, 13,000, but as on that day, 209, this is the 30,000.
Thereafter, an extension was given.
Understood,
The
but this is
original
only of a value of 30,000. Where's the truckloads?
Which stuff was?
You are saying there are truckloads of medicine which is just waiting outside.
All the other purchase orders, Lord, we have 115 purchase orders. We have got 115 purchase orders which have demonstrated. So it's a continuous supply.
No, where is that?
So that is what para 27 where we have read that.
No, show me a document where there is a purchase order there where you are required to deliver.
We have mentioned the purchase order page 161, all 150.
No, that is not yours, everybody's.
No, that is our.
Page
161 is only our, it's ours.
161.
Yes. These are all purchase orders pertaining to us, not others. 17 crores is us.
Now, understood, these are given, the last purchase order is given on 26th of August 2025. Are you saying that you have not supplied those? When the period has been given, what is the date of supply? At
Then,
page
of course, I am not
162.
actually able to assist, Kaushal. Not actually. But the
No,
fact
when
is-
you are making the statement, because you say that the truckloads are waiting outside, therefore there has to be some purchase orders.
the documents are that document which you have shown at page 222.
And secondly, my lord, where.
And even otherwise, Lordship, I have to show one document before Lordship picks up on mine. Please have their own data that have uploaded.
No,
in
this
the-
is pending orders of Assam supply. These are given on, these are PO dates on 15th October. These were given to you.
Yes. And these are breached. Delivery, stock not taken by warehouse and vehicles standing at warehouse.
Anyway, due date is on 27th December
Which user got?
in page 222.
Triple, 221, I'm showing 221. I'm showing 221. If Lordship will say stock not taken by warehouse and vehicles standing at warehouse. Invoice date, Lordship will see, one invoice date is 1911, one is 1310, and one is 25/9. Now, these are standing outside MCH Nagaon, District Drugstore Morigaon, and District Drugstore West Karbi Anglong. And even otherwise, Lordship will say, we have just one document which I ought to have shown earlier. Please see their own status. They themselves from their own website say that these products have been delivered.
So what are, it means page 161 is pending order wise sheet at page 161. This is from 1/4/2023 to 30/9/2025. Isn't it? This is the PO value you have supplied.
Still remains is this.
Where?
What remains is page 222.
222 is being issued only on 15th October.
Third one, there should be supplied.
The due
69
date,
lakhs for.
the due date is on 27th December.
I'm saying 27. This is still remains to be supplied out of the 17 crore. That is why we have made it separate.
It can't be. This can't be a part of the 17 crores because the 17 crores comes under 115, page 162. Kindly see. The last is 26th of August 2025.
And secondly, my lord, after issuance of the department.
Please see 11/12.
2025, what date should the invoice get at 1911?
11/12.
Then knowing that, my lord, department notice has already been issued on 17/11/2025. The date will 21, my lord. One invoice is dated 19/11/2025, my lord. After issuance of the department notice, why they issued the invoice dated 19/11? They are taking risks at their own, my lord. They out of the one, my lord, one invoice is, my lord, dated 19/11/2025. And department notice was issued on 17/11/2025.
See, but that, for example, Lordship will kindly see that, Lordship will kindly come back to page 160.
Will kindly come back to page 160 or more. Kindly come back to page 162. Serial number 111 and 112. If purchase will note the purchase order numbers, they exactly match with the invoice purchase of at the trucks loads purchase order numbers. Up to 2. 11 and 12. If purchase will see the document at page 221.
The first one is 26/8/2025. These are the dates. But why these dates?
If purchase will come to that list of 115 purchase orders,
Yes,
and if purchase will come to
112,
and
then 113 and
111 and
112,
112.
112 and 113. Isn't it?
Yeah.
78 and 17. Yes, 112 and 113. And what about 17? Uh, 516.
First one.
The third one is also the same, na?
Same.
Third is, so it is in 112 and 113.
Yes.
So, Annexure A, page 213 are not in respect to these purchase orders. Annexure A to the debarment notice, debarment order, page 213
Yes, sir.
are not in respect to these purchase orders.
Yeah, they are not in respect to this person. This is a continuous supply loss. Those are 4 purchase orders pertaining only to this one. So issued in March. And another aspect of this, even their own website indicates that there is 100% supply. Within their own website, MRC website, I have shown that page. The website itself says there is 100%. Those are pages we have downloaded from their own website. MRC, when product reaches, so they update their supply position. So those pages itself indicated, we admit that one product we couldn't. But see with respect to the other status instructions. This starts at page 214.
What will happen if I grant you a stay today?
Yes.
And you supply, and later on I dismiss your reputation? How do you take care of that?
We think we have a reasonably.
No, you think, but the question is, well, you can't put the horse back again.
Yes.
That is why the problem arises there in a blacklisting matter. Otherwise, I would not have heard you for a long time. I thought that if it can be disposed of, I could have disposed of, but here I have to give them one chance to.
What we can do is, today their own statuses say that we have supply, the MRC status. As Lordship indicated, that Lordship will keep the matter very level. In the meantime, if Lordship at least stays with us, and we can participate in other tenders, because it's a letter from Telangana, please, we have put that letter also. So we are now being hounded across the country for an amount of 31,000 rupees. At least on doctrine of proportionality, Lordship, Steve. We have supplied 16 crores across Assam, we have supplied, and we are emphasizing on force majeure. Difu was flooded. There was absolute landslide. Lordship knows it. That is why our trucks could.
No, Diffu was flooded, but with the extensions which were given at that point of time, there was no floods.
Oh,
Well,
we supplied it. We supplied it in such extension period. That is our case, and that is what the MRC status says. Please appreciate. Today, because of this blacklisting, for 3 years, we are not being able to participate anywhere.
that is the problem. Now, tomorrow I therefore dismiss your petition by any chance. Then what will happen to those participations which are doing everywhere?
We face the consequences naturally because then we have to declare it that we have now been blacklisted.
So therefore, you have already been blacklisted, but you, by way of a stay, you can participate. These have a lot of opposition.
But then, what I'm saying, let the state be till 11. Let the matter be. In the meantime, as there are tenders all over, let me participate. Today I have to declare that I cannot participate because there is a blacklist.
We can do, you have been debarred for these 4 products. Now we can stay.
No, firm is debarred.
Anyways, the firm is debarred. We can just put it in a interim order that it shall be a, for the interim order is only that in respect to these 4 products. In fact, that was the order which was also passed in another matter of this. Sahiwala. Where is Mr. B. Gupta?
There the issue was different, my lord.
Issue was different, but then also the court said that the debarment shall only be in respect to those products where he has been.
My lord, there is 2 issues, my lord. The department in respect of product and farm department. When there is default in respect of more than 3 products, my lord, then the farm department clause is applicable.
So here there are 4 products.
Yes.
But that is when we are disputing
And
it.
the dispute is that they are saying that they have supplied, but the last department notice, state, my lord, because it is a question of facts also, my lord. Disputed facts, my lord. They are saying they have supplied, but our notice says that they have not supplied, even after the extension, my lord. And the invoice date, one invoice has been issued after the department notice, my lord, on 1911, my lord.
Well, but that is a continuation of that particular work order which was issued in the year 26/8/2025.
Yes, my lord, that is true. But my lord, when department notice has been issued, my lord. So after that, why they have issued the invoice date on 1911, my lord? Page 209, my lord. It is 213, my lord.
What?
213, annexure A to the department notice, it says your delivery status as on 14/11/2025.
It's by the.
And this is the disputed fact because they are saying that as on that day, my lord, they have supplied more than the quantities that has been reflected in the department notice, my lord. They are claiming that, my lord, before issuance of the department notice, my lord. It is 17/11/2025. In respect of 3 items, they have supplied more than 90%. But the department notice says that as of 14/11/2025, their supply rate percentage of delivery in respect of all the four products are less than 90%.
When these purchase orders are continuing, approximately takes triple two. Purchase orders are of 15th October, 16th October. It should all have to be supplied now.
No, but the impugned, the allegation is in respect to certain purchase orders of the year to 1/3/2025.
But now these purchase orders of 15th October, 16th October, 17th October, which are case triple two, will also have to be supplied. They are recent purchase orders. These are pending. We have already, some we have dispatched, some is on the way to dispatch. These are recent purchase orders. And real lordship, as much.
So what is the value of these as per this? As per you, it's different. Your purchase orders are.
69 lakh, this is valued at 69 lakh.
No.
This, what is that page triple two? In fact, the core purchase orders were the next. But you would like to have a look at the purchase orders itself. That starts from page 163, annexure 8 column. The first one, lordship will see, is lordship at page 163.
So these 13,000 is, what is the date on which it is? Because there appears to be two different things. They say it is 30,000. You say it to be 13,000.
We say that there is one medicine admittedly we go to supply.
No, it's okay. But the question is, if it is less than 90%, then there another aspect comes into it. So when did you make these supplies? Why there is a discrepancy between the two?
Yes, yes. These supplies.
Because you say, as per you, the supplies were made in the year on 16/10/2025, the last one. Meaning thereby, why in your reply, which was issued, the extension which was granted to you,
The last extension was granted on 5/11/2025,
yes, 5/11/2025,
saying that give it to us. in
where,
7 days.
on 5, as on that day,
Yes,
5/11/2000, but you have already supplied. What is your reply to this?
that is what the MRC data. The reply is their own document where they received this products after this. The 5th on 5th, they give us 7 days time. So the cutoff was 12th. So I had to supply before 12th. Before 12th, I supplied 3 medicines except one.
No, it couldn't have been because of the fact, as on 5/11, your last of the supplies as per your 13,000 things. 13,000 thing, which you have given,
Yeah.
is on 16/10/2025. If it is 16/10, so as on that day, it could not have been 209, as per 209.
Thereafter,
Why is the question of thereafter? If you say you have supplied this as on 16/10. As
One
per-
chapter.
Yes, your chart. You say that the last of the supplies were made on 16/10. If that be so,
That's not the last supply.
no, in respect to these 4 products, we are concerned with the 4 products.
Correct.
We are not concerned with other. Now, in respect to these 4 products, where they have issued those purchase orders or whatever may be, then as on 16/10 is your last of the supply.
There could be a mistake here, that is not correct.
Then this document is wrong. Kindly see, read it.
That could be last supply is on 12th of November.
No, no,
Last
kindly
supply.
read
Yeah, I've
it.
seen that, I've seen.
Then
that.
it is wrong.
Others.
No, this is not clear. You have not placed it properly. You have it after vacation, no impact. No, this is not the case. Why have you prepared and given me a chart which is not proper? If it is, here it says that on 1610, and here you say, as on 511, they continue to say that there has not been the supply,
Yes.
which means it is wrong.
Please, I apologize for that. Please, it is their own document and MRC status where they accepted that on before 12/11 or of 12/11, they got these products.
Where is that?
Yes. Please come to page 214. This is their own document now. MRC MRC stands for Material Receipts Certificate. Now, Lordship, see the, kindly come to page 215. MCH before.
Yes.
Item receipt 12/11/2025. Ordered quantity 700, supplied quantity 700. We don't know how they say remaining or quantity 700. Because ordered was 700, they have received 700.
Then also they say MRC
MCH
status 0.
It could be a data entry mistake.
This is no value.
No, this is their own document. Lordship. We have downloaded it from their own website.
No, everything has yes. In that case, it is no. So that means they don't have the data.
No, they have said that ordered quantities was supplied quantity 700.
Remaining quantity 700.
Yeah, total
And-
was 700.
No, then you see MRC status no. Whereas in others, they have said yes.
Precisely.
So therefore, there is no MRC status for that.
But they received.
Where is the receipt? Remaining, can we say that, okay, you go for the remaining, you don't go for the other one? The outstanding is also not there, which is not.
Total quantity was 700. The total quantity applied was 700.
But here also they say remaining is 700.
Therefore, that's a mistake we are saying. On their part, please don't, we should not suffer for that.
Absolutely understood. For that, this particular document, then how can we rely on this document to say that you have supplied?
Applied quantity 700. They-
Where is any document to show that you have supplied? Because that is the question out here. Why on 511, you have not mentioned when did you supply? How much you supplied? There's nothing. Where is your reply to that? On 511,
No reply was called for. You were just told to supply within the next 7 days.
but the show cause is only in respect to 4 numbers of PO, where supply is found below 90%.
So they also accept there is a bona fide dispute. We say we have above 90, they say we below 90. That's a bona fide dispute. Now, in that situation, Lordships, when there is a bona fide dispute raised, blacklisting the last resort, which Lordships have also held Supreme Court also said. When there is a bona fide dispute, and here we are saying there is a dispute which they also accept.
Show me that as on so and so you have supplied so much. Show me a document to the effect where you have said that you have supplied this much, except that MRC has no value, taking into account. Where is that email?
Page 201 with the GST invoice. Page 201 of Vegas place. Dear sir, this is with reference to the trading date. We would like to inform you that we have dispatched the goods to the respective warehouses as detailed mentioned below. And these are the 3 medicines Lordships.
Yeah, here you find the date. At least it displays date 1610. As I was showing it to you, 1610. So this was given on 28th.
Yes.
So
28.
therefore, it must have, is your and delivery, when was the delivery?
And next 3 pages are the GST invoices with respect to them.
Letter issued from ASLR for your information.
Your
kindly
lordship will see it's all addressed to before. So there is a supply lordship, it is not that we have not supplied. And these, the purchase orders are also indicated in the GST, what's on the right hand side.
There are 3 only purchase orders against 4 items.
Yeah, because we are considering that one product lordship we could not.
Which one?
That is ceftriaxone powder for injection. Ceftriaxone injection powder. 600.
So if you have dispatched on 1610 or 1010, when was it received?
What the demands.
And MR is problem to trust it, no?
Otherwise, the MRP is defective from one end.
No, there are other variables. Please see all the pages. MRC is with respect to all the 3 minutes.
Order of,
Name of what? This 3 medicine.
17, right?
This we have downloaded on 1811.
This you send it where? Diffu, na?
This only diffuse, only diffuse concern.
MR status all Diffu, this is the same one.
The medicines are different.
No, page 214 and 214. Then
The names of the medicines are different. If lordship will see page 215 is Proctri, that is Proctrinsolol. And then lordships, the next is at page 216, bottom of the page 11. Prednisolone 1 tablet. And that continues to page 217. Lordship will see prednisolone, yes, 34,300.
kindly come to page 216.
216, yes, good. 216, bottom of the page.
Yes,
MCA
here also the bottom of the page, 34,000 remains. 34,300 remains.
Yeah, and then the next page is 34,300 is supply.
No, MR status is no, you see.
Supply quantity, accepted quantity. That is the whole issue.
No,
This is a.
Mr. Kindly see, supplied quantity is so and so, accepted quantity is 1045. Then remaining is this.
34,000.
Ah, so there you have not supplied.
Now what's the third page is this one, 218. Limp, period of 9.
No, I won't pass her into model. Issue notice. No. Issue notice making it returnable on.
Can I just say the bona fide dispute? Cannot should not protect for.
No.
There is a bona fide dispute, they are claiming.
No, we'll have it on 11. No, heavens will fall. You could wait from 1711. You see, you could wait from 1711. This court is only asking you 11 days. We'll take it up and finish it off. Issue notice making it returnable on 11th of December 2025 at 2 p.m. Mr. D. Bora accepts notice on behalf of the respondent numbers 1 to 6. Extra copies of the writ petition be furnished upon him during the course of the day. The petitioner herein is aggrieved by the order dated 15/11. Uh, 17/11/2025. Issued by the Managing Director of the Assam Medical Service Corporation Limited. That is the respondent number 4. Whereby the petitioner's firm have been blacklisted and debarred from participating in any tender for 3 years from the date of issuance of the said letter for default in supply of 4 numbers of essential drugs against 4 numbers of POs, which were detailed out in Annexure A to the said communication. Mr. M. Goswami, the learned senior counsel, appearing on behalf of the petitioner, submits that the amount for which that as per the petitioner had supplied more than 90% in respect to the 4 purchase orders and purchase orders. And as such, the question of debarment of the petitioner's firm was not in consonance with the tender conditions as well as the letter of intent. Full stop. Per contra, however, Mr. D.P. Bora, appearing on behalf of the respondents, submits that in terms with the communication dated 17, in terms with the impugned communication dated 17/11/2025, the supply in respect to the 4 items in 4 purchase orders was not 90%, but was far less. He therefore submitted that taking into account that the respondent authorities have provided the petitioner adequate opportunity by granting various extensions, and in spite of that, the petitioner having failed to submit within the time granted as per the extension, the question of invoking the jurisdiction under Article 2 to 6 of the Constitution does not arise. This court may not like to exercise the jurisdiction under Article 2 to 6 of the Constitution. Mr. M. Goswami, the learned counsel, senior counsel, appearing on behalf of the petitioner, however, submitted that there is a bona fide dispute as to what is the quantity of supply made, in as much as not only the details which is being furnished by the petitioner, but also from the, what is that, MRC is what?
Medical receipt settlement.
Medical receipt Chalan
Center.
Center.
Certificate.
Huh?
Material receipt certificate.
Material receipt certificate, status of the purchase orders would also indicate that the quantities have been duly received. He therefore submitted that a blacklisting or the debarment which have been ordered, ordered by the impugned communication is required to be stayed pending disposal of the writ petition pending the next day, inasmuch as not only it would result in the petitioner being not able to participate in various tenders, but also the petitioner but also truckloads of materials, the details of which have been given in page 221 as well as 222 are required to be supplied at page 221 are waiting before the warehouse, are standing before the warehouses, and there is also a likelihood that they are not perishable, na? Waiting before. Yeah. He further submitted that there are further pending orders given by the respondent authorities on 15 and 16th of October 2025. Pending or 36 pending orders dated 15 and 16th of October 2025, wherein also the petitioner have taken appropriate steps for delivery of those items. This court heard the learned counsels appearing on behalf of the parties on the interim directions as to whether any interim directions are required to be passed. It is the opinion of this court that the respondents has to be given an opportunity to obtain instructions and place their stand by way of an affidavit. Inasmuch as this court further is of the opinion that if any interim order passed today, it would be amounting to granting the final relief at this without giving the respondents an opportunity. Under such circumstances, it is the further opinion of this court that the instant petition requires an early resolution of the disputes. Accordingly, this court therefore grants liberty to the respondents to bring on record their stand on or before 5th of December 2025. Liberty given to the petitioner to file reply by 10th of December 2025. It is observed that if no affidavit is filed by the respondents on or before 5th of December 2025, this court shall consider passing off interim directions on the next date if the writ petition cannot be taken up for disposal, final disposal.
Yes.
I can remember second I had some difficulty. Could it be the Monday or Wednesday?
Monday.
So it had been issued, my lord, with the private respondent. It was issued in 26/11/2020.
24.
20.
Then
No information provided. No information provided.
what is the information? You have taken the bank. You have not returned also.
The other page, my lord, we see the communication of September 2025 to Commissioner of Excise to grant him a license. Behind that.
Nothing remains. What to do?
We reserve our right to challenge this order dated 23.
You withdraw
We have withdrawn with the liberty.
liberty to challenge this. Better. Heard Mr. S. Count, the learned counsel appearing on behalf of the petitioner. And Mr. I. Botaku, the learned counsel appearing on behalf of the excise complainant. The petitioner herein have assailed the acceptance of the technical bid in favor of the respondent number 6, as well as all consequential actions for grant of Indian-made foreign liquor retail off license for the shop named Dhokwakhana Town number LKP 21 in the district of Lakhimpur. And further sought for a direction that the respondent authority should consider the technical bid of the petition and allow him to participate in the financial bid for the grant of the Indian-made foreign liquor retail off license. It is seen from the materials on record that as far back as on 24/12/2024, the EMD so submitted by the petitioner was returned, was credited to his bank account. The petitioner thereupon submitted a representation on 9/12/2024 and the present petition was filed on 20/11/2025. Taking into account the above, this court therefore sought for instructions from Mr. I. Botakur, the standing counsel of the Excise Department, as to what steps have been taken, taking into account that almost 1 year have already elapsed in the meantime. Mr. I. Botakur has placed before this court that the respondent number 6 bid for the Indian-made foreign liquor shop license at Dhokwakhana Town LKP 21 was accepted on 23/12/2024. Further to that, on 2/9/2025, the District Commissioner Lakhimpur have also requested the Commissioner of Excise Assam to grant the license to the respondent number 6. The said communications are kept on record and marked with the letters X and Y respectively. Taking into account the above, the learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant writ petition. And liberty may be given to the petitioner to assail the allotment of the Indian-made foreign liquor license off license to the respondent number 6 and challenge the decision to allot the Indian-made foreign liquor license liquor retail off license to the respondent number 6, as well as the consequential actions. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. Liberty, however, is given to the petitioner to assail the decision to allot the Indian-made foreign liquor off license to the respondent number 6, as well as the challenge made in the present writ petition.
Item 50 and 51, respect to care.
Yes, what did you find out? You're gonna-
Well, my lord. The readers have to fill it, my lord, and have to submit with the fixed my lord. And clause, my lord, 14,
PAN card.
nine PAN card, my lord. But it's not taken, the PAN card is required to submit, the number is sufficient, but 14 is Bakizai Praman Patra, that is for and undertaking is there, my lord, let's find the undertaking also that they will submit. Good, that is.
So he did not submit the Bakizai.
Why can't it that your worship the Bakizai certificate was not at all required document? So it has not been mentioned in the NIP.
But in the form,
Yes.
Regarding form, your worship,
form is a part of that.
Yes, sir.
Isn't the form a part of the tender document?
Exactly.
Isn't it mentioned in the notice inviting tender that the form has to be given on the basis thereof? Where's the notice inviting tender?
you will find that there 22. 22 and the Bharat. Just 20 times. I can say if you have to be a worship, but not right.
Clause 6. Clause 6 is saying গোয়ালপাড়া বিদার পরিষদে দোকান ধরা মূল্য নিবিদার প্রপত্র এ নিবিদা দাখিল করিব প্রপত্র is that form.
Let us read the entire clause 6. What is that document 18-8, which went to the Supreme Court and Supreme Court says that mandates it, that should be a part of that it is in the case of fishery, no? Only fishery. No, but that notification is only in respect to fishery 18-8,
Only in the.
where it says that all these things should be mentioned or made a part of the tender. It's only for fishery. So then, without the Pakija notice,
I can see that the one, the tender is required to be submitted as per terms and conditions of the NI.
it includes the application form also.
But apart from that, you have to carry some force. Rule 23 sub-rule 15. If any document is required to be, then the evaluation committee may issue.
May not also.
But if the instant case, you have no notice has been issued. No notice has been.
May or may not.
But form itself is saying, madam.
Ah.
It's not additional one.
Of the case is that kind of the condition reverse laid down in the NIT or what is that? I think that condition will fulfill your lot, the kind of submitting the.
What did you say? Isn't this your form? What is his name?
Two petitioners are there, two forms are also there. Both the petitioner has submitted that.
Pradeep Kumar Nam. I kindly read the last portion, the certificate, undertaking.
Yes, undertaking is there, your lot.
What is that?
I see. Moi Sri Pradeep Kumar Namadar, Walpa, Sida, Puripur, Kijatis, Francis, Kumar Baba, Hakosa, Kumar Adi, Kumar, Nevada, Akamar, Ramani, Santumok, Kumar, Pure, Yato, Al Prostomu, Manigobe, Bataraki. Purapur, India, Sepulchre, Belgica, Axomu, Officer, Sotuno, Ole. অথবা শর্তাবলীর কোন শর্ত ভঙ্গ করিলে পঞ্চায়েত আইন অনুযায়ী মোট বিরুদ্ধে প্রয়োজনীয় ব্যবস্থা গ্রহণ করিব পাৰিব মই দাখিল কৰা নিবিদা কোনো ফলক আৰু উক্ত নিবিদা লিখিত হলে সম্পূৰ্ণ টকা বন্দোবস্তি জানানোৰ
Now, Mr. Council, when you have submitted this form, this is your form.
Yes.
Can you now say that where it is mentioned, Bakizai Praman Potra Dakhil Koribo Lagibo? Can you now say that this cannot be taken into consideration?
I just want to submit volume one. That is the bids are required to be submitted as per the terms and conditions.
Understood,
Laid
but
down in
the,
that
but,
NIT.
but the bid also say, the terms also say that it has to be in compliance with the form to be submitted by the Gwalpara Zilla Parishad. And it is a fact that you have submitted this form. And in that form, you did not place the Bakizai notice. PAN card is different because they don't mention the PAN card that you have to place.
What is the condition number 6 here, Lordship? I just want to see the opinion. The condition number 6 of the NIT. গোৱালপাৰা জিলা পৰিষদে যোগান ধৰা মূল নিবিদা প্ৰপত্ৰত নিবিদা দাখিল কৰিব লাগিব। It means the tenders are required to be submitted in the tender form which are supplied by the elaboration.
So there is a condition that you have to submit the Bakizai notice certificate. How do you take care of it?
But in here your condition is there, but that condition I am I just want to say that that condition is not the part of the
But
NIT.
you saw this, you have signed this document. But you did not submit that. How can you take up that plea? So therefore, it was a non-responsive bidder you were.
Although it is in here, but it is not within the part of the NIT.
You cannot say that after signing this
And
document.
the NIT only talks about that the bidders are required to submit their bid in the form supplied by the decoration,
Yes,
but not in accordance with the particular given in the form. It is as per the condition number 6, what is the condition number 6 that talks only about the bidders are required to submit the NIT in the form supplied by the developer, but not in accordance with the particular given in that.
it's too hyper-technical, don't you think?
This document was written in clause 6, man. Proper term. This is the proper term. In its written. It was supplied with the documents.
The proposed was given that is pretty well.
This document was supplied with the tender form, my lord. They have filled up it and signed it and submitted, man, with the bills.
You heard Mr. A.M. Khan, the legal counsel appearing on behalf of the petitioner.
And
Mr.
As per the
S. Doctor, the legal stand-
apart from.
No more. That day it was already dismissed. I allowed it. No more. First of all, you should have enclosed this form. Why haven't you, if it is a part of the tender document, why have you not enclosed this form?
But that document, your lordship, it was-
Now, isn't this a part of the document, tender form?
Yes.
is the part of the. Yes.
Then why haven't you, we dismiss it on this only? We'll let us go. We dismiss it on suppression of material facts. As Doctor appears on behalf of the respondent numbers 1, 2, 4. 1, 2, and 4. Mr. So-and-so appears for the respondent number 5. The petitioner herein have assailed the actions on the part of the respondent authorities in cancelling the tender process initiated by the NIT dated 5/6/2025 for the period 2025-26 for in respect to Buduchor Daily Market, as well as issuance of the re-NIT dated 25/7/2025 in respect to the Buduchor Daily Market. The materials on record reveal that on 5/6/2025, the respondent, the chief executive officer,
Yes.
the chief executive officer of the Gwalpara Jila Parishad had issued a notice inviting tender for settlement of various huts, including the Buduchor Daily Hut. Pursuant to the said tender process, at the notice inviting tender notice, the petitioner, along with another bidder, namely one Minoti Koimbatoor, AAYBART, Koimbatoor, participated in the said bid process for the Buduchor Daily Market. It is the case of the petitioner that Minoti Koimbatoor, that the other bidder, namely Minoti Koimbatoor, was not technically responsive. And as such, the petitioner ought to have been granted the settlement in respect to the Buduchor Daily Market However, the respondent authorities cancelled the said tender process initiated by NIT dated 5/6/2025 in respect to the Buduchor daily market and floated a fresh tender on 25/7/2025 in respect to various markets, including the Buduchor daily market. And it is under such circumstances the petitioner has approached this court by filing the present writ petition. The record reveals that this court, by an order dated 4/8/2025, issued notice. And further, taking into account the stand which was placed on the taking into account the submissions made by the learned counsels, taking into account the materials placed at the time when the writ petition was moved, passed an interim direction that the respondent numbers 1, 2, and 4 would be at liberty to proceed with the tender process initiated by NIT dated 25/7/2025, but however shall not finalize its decision in respect to the Buduchor daily market till the next date. Full stop. This court further, by the order dated 4/8/2025, permitted the petitioner to participate in the said re-tender process initiated by the tender notice dated 25/7/2025 without prejudice to the present proceedings. Full stop. It is an admitted fact that the petitioner, however, did not participate in the said fresh tender process. Be that as it may, the respondent number 5 was adjudged, was evaluated as the highest bidder.
There are 4 responsive bids was there. After financial open, bid open, there are 3 bidders who will answer. Bids are same.
And be that as it may, in the meantime, the respondent number 5 was evaluated as the bidder who is entitled for settlement in terms with the Buduchor daily market. Under such circumstances, the respondent number 5, in view of the interim order operating, filed application for seeking impleadment in the instant proceedings, as well as also for vacation, modification, and or alteration of the order dated 4/8/2025. So the learned coordinate bench of this court, by an order dated 18/9/2025, impleaded the respondent number 5 as a party to the instant proceeding and further vacated.
No, not that.
Yeah. Did you file a vacating application?
Only implement application.
Oh, implement.
And only they have been, only implement.
Have implemented and a vacating file. You have filed an application seeking implement, and the learned coordinate bench of this court, by an order dated 18/5/2025, have impleaded the respondent number 5 in the present proceedings. Taking into account that there is an interim order, this court, by an order dated 19/11/2025, have fixed the instant writ petition for disposal on 25/11/2025. On the same date, when the matter was taken up, a question arose as to whether the petitioner herein can be held to be technically not responsive in the evaluation so carried out on on the ground that the petitioner did not submit the Bakizai document as well as the PAN card. Full stop. In as much as the tender document, a perusal of the tender document, which had been enclosed to the writ petition, did not disclose, prima facie disclose the requirement of the Bakizai document as well as the PAN card. Full stop. Under such circumstances, this court fixed the matter today for obtaining instructions. Mr. S. Dr. the learned counsel appearing on behalf of the PNRD department submitted that a perusal of the tender document, more particularly clause 6, would show that every bidder is required to submit the tender in the form supplied by the Goalpara Jila Parishad. Full stop. He further submitted that this form is a part of the tender document, and as such, the petitioner ought to have enclosed the said document along with the notice inviting tender while filing the writ petition. Be that as it may, the learned standing counsel for the PNRD department produced before this court the form so submitted by the petitioner. Full stop. A copy thereof have also been provided to the learned counsel appearing on behalf of the petitioner. The said form is kept on record and marked with the letter X. A perusal of the said form reveals that various details are to be furnished along with certain documents. At clause number 9 of the of the said tender of the said form, application form, there is a requirement of furnishing the PAN card number. At clause number 15, 14, clause number 14, it is specifically mentioned that the Bakizai certificate has to be enclosed. Admittedly, the petitioner did not enclose the Bakizai certificate. Under such circumstances, it is therefore the opinion of this court that the evaluation so carried out, whereby the petitioner was also held to be technically non-responsive on the ground of non-submission of the Bakizai certificate, cannot be faulted. Full stop. This court further takes note of that the respondent authorities, having found that there was no technically responsive bidder in pursuance to the notice inviting tender dated 5/6/2025, in respect to the Buduchor daily market, have therefore taken a decision to go for a fresh tender in respect to the said market along with the other markets, as could be seen from the tender notice dated 25/7/2025. Considering the above aspects, it is therefore the opinion that this is not a fit case for exercise of jurisdiction under Article 2 to 6 of the Constitution, inasmuch as the actions on the part of the respondents to cancel the earlier tender process initiated by the NIT dated 5/6/2025 and further going for a fresh tender dated 25/7/2025 in respect to Buduchur daily market do not require any interference. Writ petition stands dismissed with cost quantified at rupees 10,000. No cost. Interim orders passed earlier stands repeated. Yes, the next one.
Next one, he participated second time, my lord.
Participated.
Next one,
You participated beforehand.
Yes. Wait,
You did not take the leave of the court and participate. You cannot challenge that.
I just wanted for one, this 59 year of tax. For
of the preliminary opposition filed by them.
Paid?
Nine.
Okay. Yes.
Page 59 is the notice from under rule 23 sub rule 50 regarding furnishing document here.
Hmm.
Here in the document is called Bakile certificate, police report and Patka.
In fact, it should have been rejected. You were given the
But
opportunity.
in earlier case, your lordship, that
Forget about the earlier. Earlier is disposed. Earlier has no business out here. Both matters are different. Now come to this point.
mind one.
No,
Why is that your lordship?
absolutely
The
no.
petitioner has been created,
Here you have participated.
they have participated, but it was under compulsion.
They cannot be. You should have taken the leave. You could not have participated out there without the leave. Like in the earlier case, I granted you the leave without prejudice. Now you have participated with prejudice.
But after participation, your lordship is initially.
Understood. Therefore, I'm saying.
And I have made my statement, your lordship, in the petition that under what circumstances,
What was the circumstances?
under compulsion, because initially.
What was the compulsion?
Initially, there
You
was.
had time. You had time. The notice inviting tender was issued on 25/7. You filed the writ petition when?
It was on
11/8. What is the last date?
the last 17 of my.
No, no. What was the last date?
Initial stage,
What was the last date of 25/7? 6/8. Then?
Yes.
Then you filed it on 11/8. And then you continued to participate. You had no problem. I would have understood. After notice being issued also, then why did you submit these documents?
the document.
Then
was-
having failed now to become the second highest bidder, you want to continue. We can't allow.
In here, your lordship, in the second.
Did you, just for example, who is appearing for the respondent?
No, five.
You are appearing in the second man. Now, in the second writ petition, there's Mr. Counsel, the respondent number 5 says that I don't want. Would you like to take it?
Only
Would you like to take it?
only concerned with the-
No, I'm asking you, would you like to take it? No? Yeah. Come up with this. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S. Dutta appears on behalf of the PNRD department. And Mr. So-and-so appears on behalf of the respondent number 5, newly pleaded respondent number 5. The present petition has been filed by the petitioner challenging the cancellation of the tender process initiated by the NIT dated 5/6/2025 for the period 2025-26 in respect to the Sutarpara Pasuhat, and further seeking quashing of the NIT dated 25/7/2025 issued by the Chief Executive Officer Gwalpara Jilla Parishad in respect to the Sutarpara Pasuhat. It is the case of the petitioner that pursuant to a notice inviting tender dated 5/6/2025, the petitioner along with how many?
Along with two others.
Along with two others or one other? Along with two others participated in the said tender process. In the evaluations so carried out, it was found that the petitioner was the responsive bidder. However, the respondent authorities cancelled the said tender process in respect to the Sutarpara Pasuhat, and issued a fresh notice inviting tender dated 25/7/2025. For various huts, including the Sutarpara Pasuhat. It is under such circumstances the petitioner has approached this court, challenging the cancellation of the tender process in respect to the Sutarpara Pasuhat initiated on the basis of the notice inviting tender dated 5/6/2025 and initiation of a fresh tender process in respect to the said Sutarpara Pasuhat by the NIT dated 25/7/2025. It is relevant to take note of that the petitioner herein, before approaching this court, had participated in the second tender process, had participated in respect to the Sutarpara Pasuhat pursuant to the notice inviting tender dated 25/7/2025. Full stop. The act on the part of the petitioner to have participated in the said notice inviting tender dated 25/7/2025, in the opinion of this court, acts as an estoppel on the part of the petitioner to question the decision of the respondent authorities to go ahead with a fresh, to cancel the tender process in respect to the Sutarpara Pasuhat initiated by notice inviting tender dated 5/6/2025. It is also seen that during the pendency of the writ petition, even after the notice had been issued, the petitioner continues to participate in the fresh tender process initiated on 25/7/2025, and the petitioner having adjudged, evaluated as the second highest bidder, now wants to contest the instant writ petition. In the opinion of this court, such a conduct on the part, the opinion of this court, such act, in the opinion of this court, a challenge to, in the opinion of this court, under such circumstances, it is the opinion of this court that the petitioner cannot be permitted to challenge the cancellation of the notice inviting tender, the tender process initiated by the notice inviting tender dated 5/6/2025 in respect to the Sutarpara Pasuhat, in as much as the petitioner had submitted the bid in respect pursuant to the notice inviting tender dated 25/7/25 in respect to Sutarpara Pasuhat. Accordingly, this court does not find any merit in the petition stands dismissed. Interim orders, if any, stands vacated.
Limited Mission Item 46.
What is this?
One of the license holder of IIFL box of matter. IIFL box of matter.
You want wine shop?
Matter. He has the box of matter. The earlier landlord matter is not allowed to extend the matter to clear agreement. Therefore, matter he apply before the authority for shifting the box of matter to another location in the same town matter, the same district. Rules permit, the rule says that matter within the same district is permissible. But the truth is not allowing the petitioner to proceed.
similar circumstances, Mission of Court has already directed the authorities to allow the city. The similar orders have enacted at page 32, madam. Page 32 and page 39. Order.
Where is the, your case has also been forwarded
Yes, ma'am.
to the commissioner?
Yes. District authority, they have inquired into the matter, after all verification, they said that, on my security, the proposed location, there will be no.
You have also submitted these 2 lakhs
Yes, ma'am.
for consideration.
Yes, ma'am.
Further 3 lakhs have been deposited by him for the purpose of renewal of his license.
That is renewal. That's not.
There is no renewal question here, na? Okay, let us see. Let us hear the other side. Wait for some time. Let us have the this excise department, none is there. We can then dispose it off in terms of this. Because you want the consideration,
Yes.
nothing more than that. Within 15 days.
The next amendment rule, madam. That is at page 30.
And why do you want to shift?
Because earlier, because they rented, house, earlier, landlord, is not willing to extend the lease. The issue, they have to seek the shop,
And you want to shift from which place to which place?
in the same town, madam. Ward number 2 to ward number 6.
But for that, you have already taken the no objection. No.
The MOC has been given, and no objection has been given by the municipal authority and
Locality,
locality.
have you submitted those?
Everything is,
But then also, how is it possible that within 15 days that can be permitted? Because there is a question out there.
very little process has been done.
Who has that?
The district authority, the polytechnic as well as the district commissioner,
They have verified.
very passionate.
It can be possible. Where is that?
The page 23 number. Page 29, my lord, it says that, my lord, there will be no, there is a loss. Very bad. Page 29.
So you got the Gram Panchayat, municipality.
Page 1.
So the no problem with the distance restriction under 289, no mandi and all. And what about the people there, 294? Problem with the people?
No problem, no.
Chalo, let us wait for some time. Let her get hold of our excise council. Dispose it.
47.
You get hold of one person, I Botak or D Gogoi, whoever. Yes, Mr. Bora, what is this?
My lord, the petitioner, my lord, obtained a loan from SBI, car loan, my lord. So he was an employee of Hindustan Paper Corporation Limited. So he obtained the loan in the year 2013, my lord, for an amount of rupees 3,50,000. That is at annexure 1, page 16, my lord.
Hmm.
So he will pay the installment up to the year 2021. And after 21, my lord, the Hindustan Paper Corporation was closed down. Then, my lord, he could not pay the loan for some time. Then there was a scheme, my lord, for settlement of the loan, my lord, which was granted to the employees of the Hindustan Paper Corporation Limited. So in terms of the settlement, my lord, as paid 24 years or civil fine, and amount was worked out, my lord, and that amount the petitioner paid by borrowing money from some other person. That annexure 24, sorry,
Page, where is the settlement?
annexure to page 24, my lord. Regarding the settlement, the petitioner at present doesn't have any document, but from statement it is apparent, my lord, from the bank statement. On 1/3/2021, the petitioner deposited an amount of 45,000. And this is his savings bank account. On the top, account number 10695118564. So he deposited an amount of 45,000. So subsequently, my lord, on that description, your lordship will find withdrawal transfer full amount received for re-summer, rupees 2,277. Subsequently, that has been brought to the loan account also, my lord. And that your lordship will find as annexure 326.
Where is the reply to the communication dated 11/8/2025?
My lord, I have not had any reply, my lord. But from the
No.
your
First
lordship,
reply them, then let them take a decision on that.
my
If
lord,
if you submit out there, then they reply. If without submitting a reply, how do this court know anything? That we have done it?
my lord,
When there is, you see, Mr. Bora, kindly appreciate one thing. First, you don't have a settlement paper.
yes, because it is, because,
Whatever it may be, there is no settlement paper.
yes, my lord,
So you are to therefore mention these, that look here, this has happened.
yes, my lord. We already.
How will the court first look into this? We are in 226.
My lord, kindly peruse annexure 3, my lord. Annexure 3, my lord. The amount which was deposited in his savings bank account, that was brought to his loan account. Annexure 3, this is his loan account, my lord.
Hmm.
And this loan account, your lordship will find at annexure 1, page 16, my lord. When the rupees 3,50,000 was,
Mr. Bora, you are to reply.
Yes.
Simple question. You reply, thereafter you come, we'll see. Not now. You reply, explain it to them that this has happened. Why should this court be the first one to listen to all these things? Let the people who have issued take up with them.
my lord, my lord, the petitioner is a pensioner, my lord. Now they have, in a illegal manner, have withheld his monthly pension.
Where is it?
I have stated, my lord, and I have paid for an interim protection in that regard only, my lord.
You are mentioning that your pension account has been closed. Has been withheld.
Withheld.
Are you sure?
Sure, my lord. For last 2-3 months, my pension has not been paid, my lord. It is keeping on the whole, my lord. My lord, para 13, my lord, I have specifically stated, my lord. Para 13, my lord. The respondent bank without any authority of law has placed a hold on the petitioner's pension for the last 3 months, which is credited to his SP account number to instrument. No, they don't have it any authority to stop my pension, my lord.
Where's your latest bank statement? Your bank statement, where is your latest bank statement? Mr. Bora, you can't file this in this manner. Then how do you know any pension amount is actually deposited? Or is it a golden handshake with the Hindustan Paper Corporation? Tell me, how do you know?
Because they have informed me, my lord.
Who?
The bank authority.
You have been informed
Yes, my lord.
that they have withheld
Yes,
by telephone.
yes.
So you are now a witness to the proceedings.
No, inform me.
So therefore, so therefore, from there, the statement will be there.
But they are not issuing any statement.
File additional affidavit.
Yes, ma'am.
File additional affidavit, bringing on record the additional things.
Yes, ma'am.
But you should have yeah, I'm not finding it good.
Then, my lord, I will file an additional affidavit. Before that, I will file a reply to this notice.
Why don't you submit a reply?
Yes.
And after that, if they don't do anything,
Yes.
come back. We'll take care of you. Because it is, after all, if it is a case of your pension being withheld,
Yes, ma'am.
it's a very serious thing.
Yes, ma'am.
You come back, you submit your reply within 10, I'll give you 10 days. How much time? 7 days, you submit your reply and come back. And they don't consider, come back. Better of that is,
But
No.
these people will be still there. They are withholding my pension, my lord.
anyways, they have withheld it for the last 3 months, you could wait.
Yes.
Wait for another 15 days. Heard Mr. D.P. Bora, the learned counsel, appearing on behalf of the petitioner, who's taking into account the order which this court proposes to pass. This court dispenses with the service of notice upon the respondents. It is the case of the petitioner that the petitioner was had earlier taken a loan of rupees 3,50,000 for purchasing a car. The said loan was regularly paid from 31/10/2013 to 4/1/4/2017. However, at the time when the Hindustan Paper Corporation Limited was closed in the year 2017, the petitioner received a settlement offer from the respondent bank under a special scheme called Rin Soma to clear the pending dues for rupees 42,277. The petitioner accordingly made the payment on 1/3/2021 of rupees 42,277. And it is the case of the petitioner. And in the bank statement, it was shown that the full amount received from Rin Soma full stop. In that regard, the petitioner have enclosed the bank statement as Annexure 2 to the Annexure 3 to the writ petition. Bank statement pertaining to the loan account as Annexure 3 to the writ petition. It is the further case of the petitioner that on 11/8/2025, a notice was issued by the branch manager of the State Bank of India, Sonakochi HPCL branch, wherein it has been informed that the petitioner is to pay another amount of rupees 1,77,415 on account of the loan account within a period of 15 days, failing which the bank would initiate necessary action to recover the dues, including the repossession of the seizure of the vehicle and eventually sell off in public auction private treaty for satisfaction of the bank dues. Full stop. It is seen that the petitioner thereupon, instead of submitting a representation to the branch manager of the State Bank of India, Sonakochi HPCL branch, have directly approached this court on the ground that there is a threat that on the ground that the respondent authorities could not have issued the said communication dated 11/8/2025, and also the petitioner being a pensioner, his account cannot also be attached. Full stop. It is the opinion of this court that the petitioner ought to have first approached the respondent authorities by way of a representation to the communication dated 11/8/2025, and thereupon explaining all such facts along with the documents. Thereupon, if the petitioner is aggrieved, the petitioner can again approach this court. Taking into account the above, Mr. D.P. Bora, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would submit a representation within 7 days from today. Also, it is observed that if the petitioner submits the representation, the respondent authority shall duly consider the same. It is further observed, taking into account consider the same, taking into consideration the facts already narrated herein above. It is further observed that in the circumstance the petitioner is aggrieved, the petitioner can again approach this court. Yes, Mr. Aibot Thakur. We can dispose of as per the same order, na? We go by Mr. Kadak's order. Kadak order to give disposal to him. See the facts out there. You give the difference in the facts. Which one do you want? I think Justice Kadak's order is good. You consider it within 15 days.
Can it be minor?
30.
Okay.
Disposed. I know that.
Last order notice, granted the submitted notice.
50 and adjacent to 50/50.
Lordship. There was no specification about that, and it is totally blank, Lordship, I corrected one photograph, Lordship.
That's what it should not be worried. We will give 50, shop number 50 in the first floor and adjacent should be 50, that 2 places will be given. We have already
We're
taken.
giving an undertaking.
That should not be a problem.
And apart from that, Lordship.
We'll take it as an undertaking. If it is violate, it would be a violation of the court's order.
Lordship. And apart from that, Lordship, one thing is that they asked us to deposit the 50,000 of the traffic for the Lordship.
We'll extend it.
Lordship, I pray for that now.
When you deposit by 15th of December,
Lordship.
it may be they are requested worship for 31st December because it's the festival.
31st December. Okay. 31st December. No, Evans will fall. Now, taking into account the court was taking up the matter. To stop. Pursuant to the order passed by this court on 24/11/2000, heard Mr. K. A. Mojumdar, the learned counsel appearing on behalf of the petitioner, Mr. D. Nath, the learned senior government advocate appearing on behalf of the Lanka Municipal Board. Full stop. On 24/11/2025, an instruction has been placed before this court dated 21/11/2025, issued by the Executive Officer, Lanka Municipal Board. Lanka. Full stop. The same had been kept on record and marked with the letter Y. Full stop. Taking into account the significance of the said instruction, said communication, the contents of the said communication is reproduced hereunder. From a perusal of page A, annexure Y, BOS 2411. From the contents of the said communication as quoted herein above, it is seen that one petitioner have been allotted the space at serial number 50 and the other petitioner is also allotted a space adjacent to serial number 50 in the first floor of the business center, Lanka. Full stop. The said instruction having been placed before this court shall be construed to be an undertaking given by the Executive Officer, Lanka Municipal Board, that the petitioner, both the petitioners have been allotted two spaces, one at serial number 50 and the other adjacent to serial number 50 in the first floor of the business center, Lanka, subject to the deposit of the security money. Next. This court, by an order dated 24/11/2025, gave liberty to Mr. K. A. Mojumdar to obtain instructions pertaining to the communication dated 21/11/2025, the contents of which have been quoted herein above. Mr. K. A. Mojumdar, the learned counsel appearing on behalf of the petitioner, submits that though in the communication dated 21/11/2025, there is a reference to the serial number of one space allotted to one of the petitioner, there is no serial number mentioned as regards the adjacent space. Mr. D. Nath, the learned counsel appearing on behalf of the Lanka Municipal Board, submits on instructions that the second space to be allotted would be adjacent to the space at serial number 50. Full stop. Mr. K. A. Mojumdar, the learned counsel, also submitted that the petitioner would be in a position to, petitioners would be in a position to deposit the security money within 31/12/2025. Full stop. It is the opinion of this court that taking into account that the incident repetition has been taken up from time to time by this court, the petitioner can be permitted to deposit the security money on or before 31/12/2025. Accordingly, the incident repetition therefore stands disposed of with the following observations and directions. The Lanka Municipal Board, including the executive officer, shall be bound by the instructions dated 21/12/11/2025. Subject to the petitioner depositing the security deposit money on or before 31/12/2025. The executive officer, Lanka Municipal Board, further is directed upon deposit of the security money within the time so permitted herein above to allocate the spaces to the petitioners.
16.
Yes, what is this? Yeah, some chemicals.
Last order dated 15/10/2025. You were directed to reach the matter in annexion. As regards whether not to be bring on record. That for the calculation, purpose of calculation of the amount. If only that additional evidence.
You file additional affidavit. Okay. Now what is there? What is there to be done?
But on the basis of this, they will require to verify our claim and that part. What should be my indicate what should one order? And that's my lot order on 10/1/2025. Category, if I may be. 10/1/2025.
How much is the amount?
What is 1,50,956.
So you have filed an additional affidavit.
But we wanted that their records were not traceable. So the last order was about 15,000. Who directed it? What is it? It was on record, where was it? Even the bill of the for a particular period.
Then
But we forward. And we will go 55. I will say. The calculation of the taxes. You wonder.
you cannot base your claim on the basis of bills. Your basis of your claim shall be on the basis of certain other aspects, work order, many other aspects.
Basically, the basic.
What is that?
For the contract matter, whether you get it or not, that is also.
Huh?
Whenever for the contract matter, that is also not there. There you have.
You have made certain supplies
Got
where the receipt.
Since we have category, take the petition and annex A lordship at page number 48. Entire bills along with the calculation of the tax amount, lordship we have demonstrated. Here was the issue, lordship, that entire amount has been paid, the total amount which they have paid is 5,55,000. Hardly amount of 1,50,000 was remaining against it. And there was a categorical direction of this.
Whose document is this?
See, this is what we have supplied. These are the number of which we have mentioned, the bill number from the.
No, whose document is this?
Lordship, it is my document.
Then you have given this.
But
Go before the civil court. How can this court direct on the basis of this document? These are bills. Where is this? You have supplied some Pharaoh alarm or something.
very
So if that is being supplied, there has to be receipts.
The original that were submitted to these authorities. We only have the copies of what.
Where is the document that you have submitted the originals? Receipt for that. When you submit those documents, somebody will acknowledge that. Where is that? Civil court,
So this is of one order of someone who should be the proof that.
I
the
can't-
Verification was to be done by the authority. That has to be a document.
where is the, therefore the problem arises. This is a matter of 2005. You approached this court in 2023. And there has been very kind judges out here who have been issuing notice and all these things.
There was one more order of 5/1/2021. But it there was at page number 49. But it the lordship directed that it is the money between will be inappropriate for the court to give any consultation finding as regards the attendant. However, as ordered earlier by the order dated this, we repeat that the respondent GFT may verify the claim of the petition. At page number 50/51. Page number 50. We were on the basis of this logic that we had been making communication to them since 2014.
Understood, but how, therefore, how can this court allow this? Your document is not sufficient.
See, we only have the bills of these documents because the original fee when it was there,
No,
so at that point of time.
there is no documented effect. There are how many dismissal I use?
They will go to the civil court, Mother, then do the evidence, then.
Reduce evidence.
This is not dismissal.
This is not for this court. Okay, another dismissal. Heard Mr. H. Betella, the learned counsel appearing on behalf of the petitioner. And Mr. S. Bora, the learned standing counsel. Huh?
Issue will be time by the issue of limitations. We propose a civil court, but because there is the direction of this court, the last order we said this limitation. It was pending in this case, but only they have to verify our claims.
How will they verify on the basis of those bills?
See, all along, this was the issue because we have been.
You approached, why on earth did you approach on 1/9/2023? That is your fault.
But in the 2021, the writ petition, last writ petition was disclosed in the year 2021.
What is the direction?
That is the direction.
Where?
Page 51,
Page?
49, page 49 it starts, but order dated 5/1/2020. 8%. But this direction was not coming.
No, the problem arises every time you are coming before this court. So you take the benefit of all this time when you have come before this court.
So now what is the only issue? We need to figure just 35. Ali, of course.
Because they cannot verify.
It is only the tax amount. But it is only the tax amount. which
I think therefore it is high time that we should break it. Unnecessary filing this petition for 1,50,000. This is the third petition. Makes no sense. Contempt is their fourth. I have heard Mr. So-and-so, the learned counsel appearing on, and Mr. S. Here, Bora, the learned standing counsel of the GMC. This is the third petition filed, claiming an amount of rupees 1,50,000. How much?
Like 50,000.
So-and-so. 956. On the ground that in spite of specific directions being issued by this court, the respondents have not verified the claim of the petitioner and made payment. It is seen that it is seen that the claim of the petitioner are in respect to the year 2005. The record further reveals that the petitioner earlier had filed WPC number 1111/2007. Contempt case number 571/2007. WPC number 6404/2014. And then the present writ petition. The stand of the respondent GMC is that they don't have materials for verifying as to whether the petitioner is entitled to any amount. In pursuance to the said stand being brought on record by filing an affidavit, this court, by an order dated 15/10/2025, granted liberty to the petitioner to bring on record by way of an additional affidavit the documents on the basis of which the petitioner makes its claim.
If I may, to page 42.
Pursuant thereto, an additional affidavit has been filed.
Page number 42, circular. Para number 7.
The perusal of the said affidavit
Para 7.
reveals that the petitioner have enclosed various invoices of the year 2005. However, there is no materials brought before this court that these supplies which were made, for which the invoices have been enclosed as annexure B to J, B to K, were received by the respondent GMC. In addition to that, there is also no materials to show that the original documents which were submitted by the petitioner as claimed were received by the GMC. Considering the above, it is therefore the opinion of this court that the jurisdiction under Article 2 to 6 of the Constitution cannot be invoked, as there is no materials on the basis of which as there is no admission on the part of the respondents in any manner whatsoever in respect to the claim of the petitioner. It is also the opinion of this court that such dispute can only be adjudicated by a competent court of civil jurisdiction, wherein evidence can be adduced. Accordingly, this court, therefore, dismisses the instant writ petition on the ground that the present writ petition is not a fit case for entertainment, for being entertained under Article 2 to 6 of the Constitution. Liberty, however, is given to the petitioner to approach the court of competent civil jurisdiction if so advised. It is further observed that the periods during which the various proceedings filed by the petitioner from time to time claiming the said amount as claimed in the instant writ petition be excluded while computing the period of limitation, inasmuch as it appears that the petitioner have been diligently and bona fidely pursuing the present proceedings.
I will take.
Yes, Mr. Agarwal.
Leads to non-disbursement of transfer subsidy for 2 quarters.
On the ground that the, at the time of execution, the factory was found to be closed. But the issue is decided as to whether the industry will be decided to transfer subsidy. On the
All pleadings are complete.
pleading form.
We have it on a break fixed. Can't be possible like this. When list this matter, taking into account that the pleadings are complete. List this matter on 3rd of February 2026. 3rd. On which state an attempt shall be made to dispose of the writ petition. Liberty given to the petitioner to mention the matter for upgrading. To the parties to mention the matter for upgrading.
Okay.
You verify and pay it as per Tamsir Ali. What is there? You see, you may tomorrow come. Here, this is the amount for pertaining to which period, 2023.
But the construction of a building of the taxation, considerably, we don't have the least taxation.
No, but who is to pay?
The taxation is not the production of the farm.
No, you have to pick it up. So we therefore direct. So the payment has to be made by the taxation department.
Our, and a building of the taxation department was supervised by the PWD.
So it is not by the payment to be PWD. So Tamsir Ali won't apply. Mr. B. Gogoi, the learned counsel appearing on learned standing counsel of the Finance and Taxation Department, seeks for 3 weeks' time for filing a reply affidavit in opposition. List this matter on 9th of January 2026. The affidavit be on behalf of the respondents be filed on or before 5th of January 2026.
Okay.
Non-payment. We dispose of 1 month verification paid Tamsir Ali. Dispose. Your non-payment, no, this is a very, isn't that the matter where you say that you have not given?
This is not a paying my lord. It is the PWD department who have issued us and we were informed that the work was directed by the tourism department.
Can't help it, the tourism didn't do anything.
It is an admitted point of the state is saying that we were made to do this work. State is filing an affidavit on that they have made us to do this work. Because these are, my lord, on the last petition I submitted, my lord, these are making of toilets for those festivals. So they don't generally call tender. They're emergency.
No, Assam tourism have no business.
PWD
You have not filed a reply to the Assam tourism.
No, let PWD then file.
Why PWD? PWD is not the PHE.
Yeah, sorry.
Why will the PWD do anything?
No, no, PHA, I'm not.
PHE has filed an affidavit.
We have received, Monday filing will be completed. We have to serve copies, so Monday filing complete.
Not so good, Mr. Botakur. This court should not be giving you any time. Matter has been going on from June 2025. Non-payment of dues, does it look nice? People will laugh. And then the court will pass another order that to pay you after 6 months. There is another thing. So you take 6 months for filing reply, in 6 months the court passes. You are an MSME? MSME?
No.
The affidavit, as directed by this court, and the affidavit for which time was sought for by the order dated 19/11, on 19/11/2025 have not yet been filed. Considering the above, Mr. Ibotta submits that the affidavit would be filed by Monday, that is on 1/2/12/2025. Considering the above, list this matter on 15th of December 2025. In the meantime, liberty given to the petitioner to file reply in against the affidavit filed by respondent number 4 as well as the PHE department.
In case of the petitioner, vehicles are hired by the town authorities.
What?
Vehicles.
Vehicle. What is your instruction?
As per our record, my lord, we get for the 80 lakhs 36,000.
How much?
We get 82 lakhs 63,380, but as per our record, you will get 80 lakhs 36,950.
You pay this within 6 months.
Only Thailand.
4 months. In 4 months.
Okay, 8 months. There are many 6 months it is going. And this is, I'm putting this, no? No. Why do you take the Kia Carnival? Huh? Kia Carnival, what is the per day? 2 months. Two lakhs. 1 lakh per month.
8 members. There are 4 lots.
It will have paragraph
4.
3. Paragraph 3 to put koribo, huh? Police on. Swept on record and marked with the letter X. Disposed. 6 months.
32. But neglecting case, my lord.
Ah.
My lord, here also, there will be the final.
Now, today I was looking into one matter where everything is being done by the IAR. Yes,
Wait a minute. I don't have the. I know here, the what is.
it was the same order, general manager doing it.
Here, well, after proper notice, my lords, several again supply orders have been issued by the pending that. After the proper notice, several supply orders have been issued by the pending that. Because it's just even as the flying ground is saying that without a probably electric place them, particular notice is there, next week anytime place them. If it is not there, earlier order will cover.
It has been submitted by Mr. G. N. Sahiwala, the learned senior counsel, that the instant repetition, the issue involved in the instant repetition is clearly covered by the judgment of this court in the case of MS Agron Remedies Private Limited versus State of Assam, dated 18/11/2025, passed in WPC number 2556/2025. Mr. B. Gogoi submits that he would like to produce the records on the next date. But again, the same thing,
Well, if it is not there, it's not there, just place. The office.
to produce the records on the next date. Mr. Sahiwala, the learned senior counsel, expresses great urgency, taking into account that this is The present matter pertains to blacklisting. To stop taking into account the above list, this matter on 4th of December 2020. Second is too early. Fourth,
What action was taken?
second, how many matters are there? Let us see. Okay, second of December 2025 at 2 p.m. The records be produced without fail on the next date. But today I was looking into another matter. The blacklisting, everything is being done by the managing director. What is wrong with out here in these matters?
23.
But anyway, wait,
File affidavit.
okay.
What is your stand?
Can you look at the activity engineer working by bifurcating the work and against the procedures of the PSC to the tender on the manual manner.
Huh?
Tender was put in as manually, not as per.
That is the reason why you have done, so that bifurcation is done. If it is more than 20 lakhs, you had to go. So what have you taken decision? Cancelled it. Cancel those tenders.
Cancel the tender will cancel. We are cancelled.
You'll be cancelling those tenders which has been stayed.
Yes, it is tender.
Time and figure it's not better.
You do it. You don't need to be prepared. Here you, what is being challenged out here? Notice inviting tender dated so and so issued by the Nayman. Awarded so and so so and so. It is the case that although the contract was entered into, but the site was not delivered. However, all of a sudden on Iman had issued a cancellation in respect to 2 contracts which were awarded to the petitioner. Petitioner agreed by the action on her to cancel the said contract, that too without providing any opportunity. And the instruction that the reason for which the contract agreement is bifurcated into 4 divisions by months so that they are very informed there. Okay. So you have filed the affidavit. The irrigation department has filed the affidavit and has been submitted by Mr. N. Upadhyay, the standing counsel of the irrigation department. Good stuff. List this matter before vacation, after vacation. List this matter on 29th of January 2025. There's no stay, na?
There's no stay.
29th of January 2025. 29 now. 28th of January 2025. In the meantime, petitioner would be at liberty to file reply.
24.
Responding number 4 and 5 were to instruction was some relational event in terms of order 25, 8 and 8, 9. Regarding the authenticity of some documents.
So there is a stay order. You are Huh? affidavit. When? You have filed on 17/11. Okay, affidavit has been filed on 27/11. You want to file reply? It has been submitted that affidavit in opposition has been filed by the respondent numbers 1, 2, and 3 on 27/11/2025. Mr. D. Chakraborty, the learned counsel for the petitioner, seeks for some accommodations so that his client can go through the same and, if necessary, file a reply before vacation, after vacation. Yours?
Part of the take it. I'm representing respondent number 6. There's a stay for the
Can it be done next week or what?
Absolutely no. Have you filed your reply? Then don't make the submission. On 17th of December 2025. In the meantime, the reply be filed. So Mr. So-and-so appears for the private respondent number 6. 6, na? Pusta. Liberty given to file the reply on or before 10th of December. Pusta. The petitioner can also submit the reply in the meantime.
Okay.
Interim order passed earlier shall continue till the next date.
Regarding the direct treatment or the authenticity of the document parts of it.
I'll obtain the.
25.
What is this?
Tender.
The expressions. I don't know.
Ms. N. Bora appearing on behalf of the PNRD submits that the instructions have been received and would be filing the affidavit within 2 weeks. Just after vacation or before vacation?
Before vacation. This can.
List taking into account that there is an interim order operating. List the matter on 16th of December 2025. In the meantime, the reply affidavit, the affidavit in opposition be filed on or before 11th of December. Liberty given to the petitioner to file reply, if any. Interim order passed earlier shall continue till the next date.
26.
Keep lots of space to plot.
You গরম হয়েছে মানে সেটা তোমার ভয় দিচ্ছে। Here 51, what is this? You are applying for Assam Tea Provision Fund.
In this matter, was there was an e-auction notice dated 14/3/2023, not sure can you see that address? And the petitioner participated, pursuant to that notification process. And ultimately, lost his, then the bid was cancelled and his order fund was returned.
Bid was cancelled.
Yes. In 4/4/2023, sir. 4/4/2023,
Bid was cancelled.
yes. Why not,
Then what is he asking for?
subsequently, Lord, we had several written petitions for recalling of this order.
Refuse to recall the order detail. How can you be the highest bidder when the e-auction is? They inform you that on scrutiny of your bid and other way it is found that you have failed to comply with the terms of and besides in chapter 4. Notice as on the date of the e-auction and as such your bid for sale of the properties have been treated as cancelled for a year. Prior to that, when did you get?
Yes, so he filed the petition for recalling of this order. And ultimately he approves this order to court said you have not yet disposed of and dispose it of. So ultimately that has been disposed of court.
Huh?
That representation has been disposed of.
When?
It was on. In the month of June 2025, 2006,
Where is it?
102. Lord, his deed was impacted on two counts, Lord. One, alleged violation of clause 14 of the tender clause. And second is
So far as the earliest money of the second period is concerned, Lordship, it was deposited from his account. Those are the-
But whatever may be, you were supposed to file the reply. Why haven't you filed your reply?
Some instruction I received, that's fine.
Whatever you are submitting, put it on record so that he gets an opportunity.
That is the total.
But the fact remains, as on 2023, this has happened, you have come before this court in the year 2025.
Records for the 2023 itself. Then the lordship has honorable court has directed to consider our representation to deal from March.
Where?
Your lordship will find that other page number,
65?
no, your lordship. 98.
No, this one. 67,
Prior to that, the lordship was another.
90,
59, page number 59.
and there is another requisition.
Yes,
Where?
this is the third round of litigation. Your lordship, there is page number 62, second last paragraph. In view of the consent of the party, the respondent number 2, 3 is directed to examine and take a decision on the sectional representation within a period of 1 month from today.
And where is the disposal?
Disposal was not done. There after no disposal was done, we sent the reminders after reminders to dispose of. But we didn't do it. The lordship then subsequently we had to file a second order, the petition, your lordship, which is 23, which your lordship will find at page number 98. Annexure 9.
So as of now, as of date also, there is no disposal. Disposal of your representation.
Of course, the way is 10, yes.
10?
2, annexure E or 102. Now they have stated that which will.
After perusal of the relevant documents, legal position and assistance from the internal committee of the officers constituted for assistance to the undersigned to examine the matter, it is found that this office has no conclusive material to suggest the continuing disqualification on your part under so and so. In view of the sensitive nature of the matter and issuance of the earlier communication has already been refunded, the order dated so and so is not recalled. Okay, so now you are on this.
And it has been admitted that there is no continuing conclusive material to suggest continuing disqualification on your part under clause 14 of the E option 14(3), which was the only ground it was stated in the.
It is seen that in spite of notice being issued on 26/9/2025, the respondent number 2 and 3 have not filed the affidavit. The petitioner herein have assailed the manner in which the representation dated 8/4/2023 has been disposed of on a very hyper-technical ground. To list this matter again on 17th of December 2025. In the meantime, the respondents are directed to bring on record their stand by filing the affidavit on or before 15th of December 2025. Failure to do so, this court shall proceed that the respondents have the failure to do so, this court shall proceed to dispose of the petition on its own merit as per the records.
27.
Mr. Borua, what is it?
Boundary. They are saying that they have not given the position. And
You can counsel this.
there are 4 cycles of one cycle says was given the position.
So one revenue circle has been given.
Yes, sir. Another says that position was given, but due to some dispute, again, that order was cancelled, position.
So why don't you bring this by way of an affidavit
Yes, sir.
so that we can pass an order and also the reason
Got you.
why you have issued that recovery certificate?
That's correct.
Does it have only in relevance to the Moholdoi, that's the circle officer Moholdoi's area, or is it in respect to the others?
Got you. Because that, regarding the, position part also, there is one settle, who mounted a settle, I talked with the settle officer. He
That
said-
I've seen it.
Yes, he said, those are some, part of the area. Udang National Park, the forest people are saying that, that area should not be the area for prohibited area. So regarding that, they will take some time for that resolving the boundaries. In that one, that revenue from the revenue side, they have.
So then he'll be entitled to some remission. I'm not on that.
Definitely.
Here the issue is different.
Yes.
Here, if I remember, his issue is
Gotcha.
he is yet to be handed over the possession.
Gotcha.
But on the other hand, one of the officers had issued a demand certificate. And that is what he had challenged, isn't it, Mr. Bora? Yes, I remember. No, you file it by way of an affidavit as well. You can't escape like this.
So they have not given these things because they have, their signature is also there. Their signature is also their petitioner signature when they given the possession from the Mongol revenue side.
So therefore, there should be a part of it where they are fishing.
I will find my.
This is a very important aspect. If they were given on 14/6/2024 some portion,
Yes.
then they may be entitled to, you may be entitled to claim certain amount.
Yes.
So bring it on record by way of an affidavit. It has been submitted by Mr. S.R. Bolwar, the learned counsel appearing on behalf of the district administration, that insofar as the 4 revenue circles are concerned, only in respect to the revenue circle Mongoldoi, the number 1 Dorong Brahmaputra fishery was handed over to the petitioner on 14/6/2024. Be that as it may, it is the opinion of this court that the said aspect be brought on record by way of filing on affidavit. In addition to that, the respondents shall also justify as to how the impugned order dated, notice dated 25/6/2025, how they would like to, shall also take a stand as to how they would like to justify the impugned notice dated 25/9/2025 in the light of the instructions so produced before this court on 27/11/2025. The said instruction is kept on record and marked with the letter X, interim order passed earlier. Place this matter on after vacation,
Got it.
28/1/2026. The interim order passed earlier shall continue till the next date.
Great.
Where is Mr. M. Bhuya, B. Gogoi? Wait for some time, huh? Take it.
29.
Oh, this one. What about the others?
Other OCP kindly have the breakup file.
I have issued route permission with restriction to fly with it, Dibrugh and highway to streamline operators, avoid congestion and so on. So this was done in order for better urban traffic management. So these route permissions are not given. Attorney General. We are in session. So the three-wheelers are not plying. No new permit for other three-wheelers has been issued to ply in the Dibrugarh municipal area since 2019. Now, but there are some people who are plying.
The person who gets the permit before 2019, they are fine. Because some
But
vehicles
are these
created-
permits valid for all time to come?
They're renewing, I think.
Huh?
2019.
So the question is, what is the case of Mr. Botak? Then look here, you are putting certain limitations for the EV autos that you have to ply only in this route. But however, you are not having limitations as regards the other autos.
That was restricted after 2019.
You are not issued.
Yes.
But what about those which have been issued? Can they move around everywhere? Is there anything given as regards routes for these people also or no?
Is the authority-
Obviously, they cannot have a route specific. That is also another thing. That is also another thing that they cannot be given routes. Because a person may in Dibrugarh may want to come from some place to the other,
I know.
so he cannot go. Like they're taking out here, the autos out here from one place to other. Now, these EV, they are only allowed to run in that area.
Yes, madam. But only if we, the other three-wheeler vehicles purchased after 2019. After 2019, we are not.
They are not being allowed to run in Dibrugarh.
Inside the municipal area.
You are not allowing. And they have purchased later on.
Later, EV vehicles is a very new concept.
Lordship, so far as business concerned, Your Lordship, my instruction is that, Your Lordship, probably, that is not the correct position, Your Lordship. And in fact, in 2014 to 2025, we were allowed to run within Dibrugarh municipal area. Now suddenly by.
No, Mr. Bothako, one has to also understand the traffic.
That I
The
am.
traffic has also been to align and Dibrugarh has now gone from, it's no longer a small town. It has become much bigger with the national highway coming in.
And
Earlier, a person used to think that going to AMC was, we are going to a far, far distance. Now AMC happens to be as if it is in the middle. And with the highway coming in, everything just next to the highway has developed. On the other hand, the Dibrugarh Old Town, which is there, is no longer lucrative area. All big houses are coming there. Earlier, at one point of time, going to that Tirupati, there's a Tirupati type mandir, Balaji mandir out
Yes.
there.
Near the age.
Yeah, going out there, one person will think, oh, such a long distance. Forget about Balaji mandir. At one point of time, when we were young, going to Jalan Nagar mandir was a big thing. Such far off. No, Jalandhar is just in the heart.
So big campus and I could be.
You bring this by way of an affidavit, because then it will be required. If it is brought on affidavit, then we can very well pick it up. Then we can pass an order that that there is no person who is being allowed to run from 2019. No permits have been issued to any person. Because I think you have, your EV motors have come well later on.
Not after 2019.
So therefore, let us see after 2019. This is a very important aspect, taking into account the traffic, which is becoming.
I understand.
One problem now recently, another matter is there. Anyways, Miss MD Bora, the learned counsel appearing on behalf of the Transport Department, has produced a set of instructions. Full stop. It is the opinion of this court that the said instructions be brought on record by way of an affidavit, so that the petitioner gets the liberty of filing a reply. List this matter before vacation.
Before vacation.
List this matter
Sometimes when I agree with that.
on 17th of December 2025. The affidavit be filed on or before 12th of December. Liberty given to the petitioner to file a reply. Not now, why should I? I'm asking to file an affidavit. And tomorrow you may submit it, I can 48.
We have already 9,97,478.
But
4,36,197.
what is the matter? An amount which is due to the petitioner and in spite of various irregularities have not been paid.
Them file an affidavit. They are supposed to file that affidavit, Lordship.
Madam, we can proceed on 26, madam, so structure. I have asked for three.
What do they inform?
Madam, they have stated, madam, video has, madam, given the instruction that, I got only 9,97,478, madam. And remaining 4,36,197. I've asked for.
Oh, you file an affidavit. Miss Yudas, the learned additional senior government advocate appearing on behalf of the block development officer, isn't it?
Video has.
Video submits that she has received certain instruction as regards certain payments made to the petitioner. It is the opinion of this court that the said aspect be brought on record by way of an affidavit, so that the petitioner will be in a position to respond to establish this matter on 21st of January 2026. In the meantime, the affidavit be filed by 19th of January. On or before. What is this? Oh, this one. Have they filed the affidavit?
They didn't file and we have also filed our reply. We have filed a reply, they have also filed their affidavit as well as respondent.
What is their stand?
So they were there, Dr. Their stand. Their stand is that they have come to the SOP dated 2025. So in that SOP, your lordship, they have been given system generated, it's an electronic medium, your lordship, to monitor the maintenance of roads. And they are saying that the system generated, your lordship, and that is why they are not, and our, the maintenance period got extended to 27 months. Although the dependability period certificate was also from the year, which is on page 38 of the petition.
And
None appears on behalf of the PWD, na? Which department?
it's the Peter. PWD and finance.
PWD, na? Finance.
Respondent number, finance. Conversion.
None appears on behalf of the respondents. When the matter is called. Ms. D. Musairi expresses urgency in the matter, taking into account that all the pleadings are complete. List the matter on don't have a date now. On 7th of January 2026. It is observed that if the respondents are not represented, this court shall proceed with the disposal on the basis of the materials on record. Ah, this one. What is your stand now?
The conversion, they are not processing. Conversion from on to off. That if that is process for which
Where are they there?
but it's not processed.
They are not processing.
Something about the education law.
That I also understand. That is why I didn't mention anything. So we have to take up the matter on its merits. You have filed your reply, everything. You have it after vacation. List the matter on 30/1/2026. On which date an attempt shall be made to dispose of the petition, taking into account that the pleadings are already complete. Ah, conversion is not a part of this court.
Yes, and
Then, how can I go? 53.
In this case, I was asked to do this. The rest amount of use management 50 lakhs. Accordingly, I told my one property manager, I get at 33 lakhs, sell it is. If we activate in account, 33 lakhs is there. So, for me, to pay the amount, by Monday, I can.
What? What payment? Payment of 50 lakhs.
50 lakhs. Earlier.
That was directed to you on 29/8.
Yes.
Then you have not deposited.
Thereafter, they pay my, they get to pay the. Application. I have. These order,
Already last order, that was. That came from a vendor, this time. And accordingly, I was deposited before 23rd. And I.
Seven days given.
But I went for the. 20th October, my lord, I will wait it in police of my.
What?
I will wait it in police, I am mailing. And in spite.
You are a company. How can a company be in a bedridden condition?
Direct.
What director? There is only one director.
Yes.
No. Nothing that
I think 3 lakhs, my lord, already.
you pay, you consider. I'm not going to do it.
That is. Something 10 days I.
It's
By Monday, 33 lakh, we will pay.
How much?
33 lakh. 7 lakhs 42,000, only 10 days I will.
Taking into account that no payment has been made in spite of various extensions being granted by this court, comma, this court is not inclined to extend the interim order. Mr. Mitra, on 28th of this, January 2026. In the meantime, the respondents shall bring on record the stand by filing the affidavits.
54.
There are observations you made. I paid.
You have not paid twice, 3 times court has granted. That's one number?
6.
Yes, what do you have to say? What do you have to say?
Yesterday, we have entered appearance in this case.
Okay, 1 week time. There's no interim order passed, no?
Documents needs to be become better.
Huh?
Some time will be allowed so that I can find my. At least 2 weeks.
Okay, we give you 6 months, but we stayed. Okay,
They have approved this for after 4 months.
so I stay and fix it after 6 months. You are running, you run. Anyways, this is absolutely illegal. I did not grant a stay on the ground on the last occasion because he had approached this court late, isn't it?
Yes, for my instruction is technical, historical in the technical itself.
No, without there being a lottery. That's his case. How can it be given to you?
For my instruction, technical was rejected, only some ground, they want of some comment. Notary would be made logic, he is qualified in all respect. If he are unsuccessful in technical bill itself. The condition which they referred to as observed by your lordship in the order, notary would be made logic.
So you should have been ready. If his technical bid has been rejected. Yes, madam, what is wrong? Why haven't you got your instructions? It is seen that no instructions have been received. Ms. N. Bora, the Learned Standing Council PNRD submits that the instructions have not been provided in spite of the fact that the Learned Standing Council have sought for instructions from the Chief Executive Officer, which one? From the Executive Officer. Respond number 4. Respond number 4. It is the opinion, it appears therefore that the respondent number 4 does not wish to take the aid of the Standing Council. Accordingly, list the matter on 8th of December 2025, on which date the respondent number 4 shall be present through the video conferencing mode in the video. The link to be provided by Ms. N. Bora and apprise this court as regards in respect to the queries made in the order dated 7/11/2025. It is observed that in the circumstance, the instructions are provided, the appearance of the respondent number 4 need not appear.
55. Paragraph 6, page 4.
Better? What is the instruction? Huh?
Paragraph 6. First,
First flag mark.
paragraph 30.
No, he has filed an application. What have you done?
Paragraph 6 is in.
Huh?
Paragraph 6, he filed application. In registration certificate, his name is, the registration is,
No, have you passed an order? When he files an application, have you passed an order? That is what.
it was rejected on the ground that he, ownership of the vehicle could not be.
Is it rejected verbally? It cannot be rejected verbally. So therefore, it has to be rejected on basis of some order. So my only question out here today is the petitioner has submitted an application before respondent number 4. However, no steps in that regard have been taken. Under such circumstances, the petitioner, respondent number 2 here shall apprise this court on the next date as to what steps have been taken by respondent number 4 upon the application so filed by the petitioner. If you have rejected it, give him an order so that he can sell it. If you have not rejected it, hear him
And provide,
Monday.
I'll not be there with my colleague.
Wherever it is, Monday, you get that order. Chalo. What is this? You want to file this affidavit?
No, she's, my complaint on WhatsApp.
Okay. Huh? Okay,
Okay,
you file this affidavit by, you file this affidavit by 5th. It is already there.
on 9th, out of this week.
I ask you, it is already there, everything except that aspect. Nah?
Yes,
So you file the affidavit by 5th
no,
and we let us have it the matter on 10th
no,
so that he can reply.
no.
So certain instructions have been placed before this court. Under Mr. S.C. Kyle appearing on behalf of the
Custom.
Customs Department submits that the petitioner herein could not prove the ownership of the vehicle in question. This court therefore inquired that what is the fate of the application so filed by the petitioner before the respondent number 4. The learned standing counsel submits that to his instruction the same have been rejected. Under such circumstances, this court therefore directed the learned counsel, directs the respondent authorities to produce before this court the order so passed rejecting the application filed by the petitioner. In addition to that, an affidavit be filed by the respondents lists the matter on 10th of December 2025. The affidavit be filed by 8th of December. You can take this, huh?
Pending item 28.
Nobody is there, na? Where is the health? Anybody from health? No, health appears. We ask the Assam Pharmacy Council, this resident or secretary to appear. No, none appears when a matter is taken up. List this matter on 3rd of December 2025 at 10:30 AM. The Register Assam Pharmacy Council shall appear through the video conferencing link to be provided by Mr. B. Gogoi, the Learned Standing Counsel for the Health Department, for Standing Counsel for the Assam Pharmacy Council, to apprise as to why the petitioner's application for pharmacy license have not yet been considered.
For orders item 30.
None appears on behalf of the petitioner on call. It is also seen that in spite of various directions being issued by the Lozima court to take steps upon the respondent number 10 and 11, the petitioner have also not taken any steps. It therefore appears that the petitioner have lost interest in the instant proceedings. Accordingly, the petition stands dismissed for non-prosecution.
31.
1 to 3. What has happened? All these matters?
He has transferred to transport department or something. I find it within a senior pronouncing here. The affidavit has not come much. Today,
You have filed affidavit
yes.
in all these matters?
I have filed, today.
31, 32, 33, 34.
31, 34, 36 and 37 I have sent
Today.
today. Today,
Huh?
today, Mr.
Aji fan kursi item. Tell the item again.
Item number 32, 34, 36 and 37.
It have file করেছে. Affidavit has been, particular beleg order. Affidavit has been filed on behalf of the respondent number 3. On behalf of,
Akash didn't.
on behalf of Sri Akash Deep, the then Principal Secretary of the Bodoland Territorial Council. However, the affidavits are not on records. List these matters. List this matter again on 10th of December to the 11th of December. 11th. We'll go after vacation. On 21st of January 2026, the registry shall bring on record the affidavits.
Item number 35.
Right.
30. They have filed the affidavit. And you made it for the petition.
You give your name, they will give it. You are paying in other matters, no? Need a time did you?
33, 35, 38.
Now we come to 39. Thirty-five kilos, 35 nasil. Good. 39. What is this? You sought for time in the morning to file reply. To file reply affidavit.
Yes.
Because it's a very old matter.
There was more. Project.
What is the matter about? Huh? What is the direction I passed? Oh, that one. NHPC. Okay. No. I don't understand what is wrong with you. Why you are not able to file? You are to do. You did not file on merits. You are to file as to whether review should be allowed or not. What is your problem? Didn't you appear out there earlier? So what is your problem in filing your reply? I don't understand. That some documents are not there or not. This matter was disposed of as on 2023. So now therefore you are to say out here whether these people were there or not. Or whether a review is called for. They say that the particular person whom I directed is that is his client. He says that we have nothing. We have already given it to you. Direction was to whom? You are NEPCO. NHPC. So NHPC, the question is, they say that you see, we have nothing to do now. It is with NHPC. So you are therefore to sign as to whether a review is mandated or not, whether you have anything to do or not. Then file your affidavit. No more time. Taking into account the request made by the learned counsel for the respondent, number 5. So list this matter on 2nd of February 2025, the affidavit. A last opportunity is given to file the affidavit on or before 28th of January 2025, 26. It is observed that if no affidavit is filed, this court shall proceed on the basis of the materials available in the court. 40. What is it?
Here, the direction was given by your counsel to calculate the assessment as per the internal order direction. While taking up the process of legal fixed assessment, because it was found that the predecessor incumbent, predecessor incumbent, he had made an application before the excise department to give some document to verify the transaction claims made by the dealer. He didn't respond. Thereafter, the earlier incumbent, he wrote to the deputy commissioner to allow them to inspect and take extract. While and deputy commissioner directed that, and lordship on taking verification, lordship of the records, it was found that there was a letter from the.
Now what do you want?
Lordship, some new facts have come. The lordship may take it up on any other date. And lordship, on the basis of the document, the regional authority discarded the assessment on.
This matter again on 16th of December 2025.
Okay.
41. This content petition, the asked by incumbent that is the director, he has not only deliberately
not complied to order, rather he has left no stone unturned to ensure that the order is never complied. I'll show it from the record. My lord, when this matter was last time, when this matter was listed on 22/8/2025, the lordship will see what was the stand of the contender. On 22/8/2025, it was the stand of the contender was that steps are being taken to.
Mister, I'm asking you whether you have, whether it is complied with or not.
Lordship, that's, in the earlier director, Lordship, he took a decision. And, sent it to the government for approval, Lordship. That was, that instruction was submitted before your Lordship, and your Lordship after that, to implement the commissioner secretary as well as the new director. Now, the director was set. Now, Lordship, what happened?
Mr. Goswami,
Yes, Lordship.
let us not beat around the bush. On 10/11/2025, I made a specific query as to whether the order dated 4/2/2025 have been complied with or not.
Lordship, on that count, Lordship, the commissioner secretary.
Why you are asking? Are you saying that the standing council of the department would be above the court? No,
No,
I think this, we take it up with this Anil Chandra Deori.
yes, no, no.
This is an act which is contemptuous. We ask him to, no,
No,
no. No, this is a very serious thing. No, we initiate contempt proceedings against him. No, Mr. Council, nothing doing. Are you saying that the standing council, you are above this court? No, this is undermining the prestige of this court. No, we take it up. Okay, no problem.
That was,
No. You, why are you not producing this document first? Mr. Goswami, you may play your tricks with some other courts, but you try to play tricks with me. I make it very clear. You should have, why on earth you did not place this document first, wherein they are saying, I'd like to request you to pray to the Honorable Court seeking 1 month time for submission of compliance report. Why didn't you submit? On the other hand, you submitted another document which reads, I am directed to request you to kindly take up necessary steps for bringing the tender process to its logical conclusion in compliance with the High Court's order in the matter after due consultation with the standing council of the department. Means, what is this? This is very serious. I think we call this person. We have made that person a party, no? What is his name? What is his name?
Theory.
No, there he is. We get him. I think he should be. I have not till now convicted anybody, but I think he should be. We get this fellow. Joyanta Kumar. Oh, your name. Dr. Joyanta Kumar Goswami.
Same name.
We get him now. I want the matter to be taken up on 15 December with compliance and nothing else. If it is not compliant by 15th of December, this court will take a very strict action. What? 20, you can come here. I am not going to come. On 15th of December, it's the otherwise we take strong exception. Pursuant to the order passed by this court on 10/11/2025, Mr. J.K. Goswami, the learned counsel who represents the respondents, have placed before this court 2 communications. One is the communication issued by the respondent number 1 to the secretary to the government of Assam, whereby it has been mentioned that the tender process be brought to a logical conclusion in compliance with the order passed by this court or dated 4/2/2025 in WPC number 3832/2024, after due consultation with the Standing Council of the Department. The said communication is kept on record and marked with the letter X. From a reading of the said communication, it appears that either the respondent number 1 is not clear as regards the directions, specific directions which have been passed. It also gives an indication that the majesty of the court have been undermined. It also prima facie gives an indication that the majesty of the court have been undermined. It is further seen that another communication has been placed before this court issued by the director, the present director, who is the respondent number 2, to Mr. J.K. Gustami, the Standing Council, wherein it has been mentioned that to seek 1 month's time for submission of the compliance report. The said document is kept on record and marked with the letter Y. In the perspective of the above, this court further takes note of the directions which have been passed. The directions are clear as mentioned in paragraph number 58 of the judgment. There is no ambiguity to the said directions. Under such circumstances, this court fixes this matter on 15th of December 2025. It is observed that if the directions so contained in the order dated, in the judgment dated 4/2/2025 are not compliant, this court fixes here, a further opportunity is granted to the respondents to comply with the directions as contained in paragraph number 58 of the order dated, judgment dated 4/2/2025 in WPC number 3832/2024. If it is not complied with, appropriate directions will be passed for initiation of contempt proceedings. Oh, you are not there. No, you are not there. Get hold of him.
Affidavit is not my otherwise I got the payout. Somehow I got that my matters are over and less. I can tell.
Which one?
Item 28, I posted on that.
What is the item 28? Which one? The pharmacy?
Yes. I got the payout.
Where the pharmacy? List the matter on 3rd bill, on which date Mr. B. Gogoi shall obtain the necessary instructions without fail.
Okay.
What is this item? Ah, for what?
For implementing the,
Huh?
for implementing the
Oh,
police. Police are special details.
why?
And because one of the people was finally, there was the victor, page number 9.
Okay, list this matter on Wednesday in the column of implement of necessary parties. 43. 43. Okay. List the matter after the vacation on 28/1/2026. In the meantime, you file your affidavit. In the meantime, the PNRD department shall file the affidavit. 44, no? Is this for this one? affidavit of service filed. Taking into account the affidavit of service filed, list this matter on 8th of December 2025 for admission. This will be covered by my other earlier judgment. This matter is going to be covered by my earlier judgment on the next day. Yes, what is this, Mr. Why the matters come up? Service is yet to be complete. Service is not complete.
I find that the state is like Monday. And it's not after the 3, but the 4 is not available in the present address. So I find that it is Monday.
And you're getting money from him?
There's no issue.
Okay. Okay. The service upon the respondent number 4 is yet to be complete. List the matter again on 4th of February 2026. In the meantime, the interim order passed earlier shall continue till then.